Good morning, everyone. My name is Vicki Henry, and I'm your panel chief today. My pronouns are she, her, or judge. Delighted today to be joined on my right by Justice Sachs and on my left by Justice Singh. We have 6 cases on today. Several of them are impounded, and I'll try to remember to repeat this, but please don't give us confidential information. We'll use pseudonyms, for example. Each side in the appeals court has 15 minutes. For better or for worse, we do not have rebuttal here. I can assure you that we have read all your materials. We say this every month, and I feel like y'all don't believe us, but then we have to prove it to you by asking you detailed questions about the record. So I assure you we have reviewed your materials. You might see us looking at a computer screen or an iPad. That's because we try to not use that much paper here, and so all of your materials are on these little iPads. So we are paying attention to you. We're just trying to drill down on some of the factual or legal issues in the case. With that, this is the November 8th, 2024 sitting of the Appeals Court, and we'll call the first case, 2023-P-1488, Commonwealth versus MARIN. Attorney Conley.
Good morning, Honors. May it please the Court, Alex Conley for Antonio MARIN. Your Honors, I'd like to start with the Rule 36 issue. This issue basically boils down to what I see as 5 disagreed upon sections of time. There's a number of periods of time that are agreed upon, of course, but there's about 5 ones that I see that are disagreed upon. The first one is the first period of time, which gives rise to this estoppel issue. This is where Judge Nestor in the Lynn District Court had found under 276, Section 58A, that the time was not excludable under that statute.
So, counsel, could I ask a question about that? So if we don't agree with you about that, can you still win on the Rule 36 issue? Is there still enough time?
Yes, Your Honor. So basically that issue, the reason I would start with that is because that's the one that would be outcome determinative in any of, if only that one wins, it would win the whole case. The other ones, if any of the two of the other 4 issues, except for the last one, which is just the last 5 days, any 2 of those would also be outcome determinative, but it would need 2 of them to come.
I want to make sure I understand. There seemed to be a disconnect there. You're saying if you win that issue, which is July 6th through November 23rd, if I'm not mistaken, then you win?
Correct. That's about 140 days, Your Honor. My calculation, looking at the math, I think the Commonwealth's suggestion that it would be that there's about 119 days that they, trying to get the math.
I'm not looking for the math. I just want to know if your position that if you win that. Okay. So then, aside from your estoppel argument that the one judge couldn't revisit what Judge Nestor did, do you disagree with the Commonwealth about the effect of the COVID order? So
there's 2 aspects, 2 places where the COVID order comes into effect. First is the estoppel order, whether or not that is basically trumped by Judge Nestor's ruling and making that the law of the case there, as well as 1 continuance of the motion to suppress where the COVID order came into play. There was a continuance of the motion to suppress on July 22nd where the Commonwealth answered not ready for the motion to suppress because an officer was unavailable.
But I'm asking about this first period, July 6th to November 23rd. Do you agree? Is the Commonwealth wrong about the effect of the COVID order in there?
So the COVID order was effective at the time. I disagree in the sense that the judge could, make the redetermination, saying that even though one judge had already said the COVID order.
Okay, so I said aside from the estoppel argument, do you disagree with the Commonwealth about the effect of the COVID order?
Only in so much as that other issue where the motion to suppress was continued. So just those 2 issues. Other than that, the COVID order would take effect. If I'm understanding your question.
Yeah. On the July 6th through November 23rd, do you agree that the COVID order told that if it weren't for Judge Nestor's ruling, that the COVID order would have allowed those 140 days to be excluded?
Correct, Your Honor. I do agree with that.
Okay.
Thank you.
Thank you.
I apologize for the confusion.
Okay. Thanks.
So that order, I think, is important. That order is important, though, because that is the most positive period of time. That's about 140 days here. I do think that the estoppel argument applies during that time because basically all the elements of estoppel would be met. I mean, it's the same parties, it's the same action, it's the same issue.
But the Commonwealth argues that the second judge inherently had authority to reconsider the Rule 36 calculation, and they cite Commonwealth versus Moore for that proposition. What do you say to that?
So, Your Honor, my understanding of reading those cases is that there's no ruling in those cases specifically that Rule 36 calculation can be overturned by another judge. They're kind of dicta and talking about Rule 36 in general, and whether it's possible or assuming that they could, but it's never been ruled on. I think that there's never been a case that's specifically addressed whether a Rule 36 determination can then be changed down the line at the point of the motion to dismiss to avoid the harsh consequence of dismissal under Rule 36. I'd also know as far as there are exceptions to the estoppel argument, and I think the Commonwealth points to the justice being met and justice not being served by using estoppel to prohibit argument of an issue. I suggest that that's more of an issue of whether or not Rule 36 is justifiable. There's justice as to the harsh consequence under Rule 36 in general, which is dismissal of a case. It's a harsh consequence, but that's what Rule 36 does.
Would you mind pulling the microphone a little closer to your...
Yes, I apologize.
An outside voice. Do you think that they're mischaracterizing Commonwealth versus Moore?
You know, I don't think they're mischaracterized. Looking at their the argument in there, I believe they're saying that it's assumed in that case that a judge could revisit an argument. I don't know if that was the holding of it, though.
It was assumed.
Right.
Okay.
Does it make sense that if a judge makes a ruling and another judge later in the case, perhaps on further, consideration, more detailed briefing, says, no, that wasn't really right? Does it make sense for that second judge to say, well, I'm bound to let it go forward, and if the other side wants to appeal on something that I think they're right on, that's what they'll have to do?
I mean, I think in general, judges are not inclined to reconsider another judge's ruling. I know they certainly have power to do so in certain circumstances, but I just think that here that judge at the motion to dismiss didn't really say she's not, she's inclined to redetermine, she just said it doesn't apply, and she didn't really make any more specific findings than that.
So wouldn't a good reason to reconsider is if you feel that another judge has been just wrong on a calculation?
So I think usually the proper avenue to do that would be a motion to reconsider. It would have to go first in front of that same judge, not in front of a new judge, because that's just the procedure that would be in play, and then maybe for more specific findings. And I think Judge Nestor's determination was based on whether or not the continuances were based on COVID, and found that these continuances at that stage weren't COVID-based, therefore that's why the SJC order didn't apply. So I think he would have had to redetermine that, or have the opportunity to redetermine or explain further that issue. Looking at the next issue, which I think is the other big chunk of time here, is the discovery issue and the Rule 14 issue. Basically what occurred here, as your honors are aware, is that there was a disclosure made at the first motion to suppress date as to some type of evidence. It was unclear what the evidence was, what the exculpatory nature of it was. Under Commonwealth v. Taylor, basically I think that for this period to have counted against the defendant, there would have had to be some kind of finding as to that being the case by the judge. Instead, basically the judges just declined to act upon these motions. The council filed a Rule 14 and Rule 17 motion. Judge, on the November 5th hearing, declined to act on them, saying, I think in practicality we're going to set this up for another hearing where the police department can be summoned in. But counsel did everything he could to try and get those motions acted on at that point, so it would be unfair to hold that time period against him.
So did he say, no, Judge, I don't think we should do that?
Sorry, Your Honor?
When the judge said, you're characterizing it as the judge declined to act, but when the judge said, well, we're going to put this for a hearing, did the defendant say, I object, Judge?
No, he did not specifically say he objected, Your Honor, but when discovery issues are in play, and it's an outstanding Rule 14 discovery, the Commonwealth, he can't be forced to choose between receiving that discovery. If he objected, the court said, all right, waive the motion, you object, we're going to not give you the discovery because we don't have the police, we don't have anything to do with that, we don't know what the Commonwealth has, they haven't disclosed anything, we don't know, they're saying they don't even have it, maybe. He would have had to choose then between.
Why would you have to choose? Why couldn't you insist on the time and still getting the discovery?
He couldn't, he could have insisted upon the action on the Rule 14 motion without the judge saying that there was a Rule 14 issue, because the judge wasn't at that point willing to say, yes, this is Rule 14 discovery. So I don't think he would have had any other choice but to have the officer summons in. Perhaps it's a Rule 17 issue, and I think Taylor kind of talks about this in more length about the issues, about when it's discovery issues, the judge has to make some kind of finding. And I think the judge would have had to say, if she's going to want to continue the case for this period of time because of a discovery issue, which she thinks is Rule 17, although counsel is clear he thinks it's Rule 14 on the record in that date, there would have had to be some finding that the Rule 36 time is told for that. I'd move on to the motion to suppress issue as well, Your Honors. This issue is about the consent, and I think there's basically two aspects of the consent here. One is it just overly ambiguous that it wasn't proven to be a voluntary consent based on its ambiguity?
Did you raise that below?
Sorry?
Did you raise the voluntariness issue below?
So I believe it was, the consent issue was raised in the memorandum submitted supplemental to the motion to suppress. The judge didn't make a finding on voluntariness other than saying that Miranda was given.
Where was it in the supplemental memo? I didn't see it there. This is the memo at Record Appendix 42 through 47, 45?
I may have one moment, Your Honors.
I mean, there's some general sort of boilerplate about consent must be free and voluntary, but the focus seems to be on the, Mr. MARIN did not unequivocally give consent to enter the home, and the landlord was not able to give consent either. But you're not referring to his intoxication there, or the coercive atmosphere, or any of the other things you're arguing on appeal that I see.
So my recollection is it was either raised somewhere, maybe not specifically in that memorandum, if not an argument, but in any event, and I'd have to go back and look through the transcript to see how the argument was posed specifically, but the consent issue itself was raised, and the consent issue is what the judge made the determination on, and where the Commonwealth bears the burden of showing voluntary consent, that still comes into play.
So if the defendant says the firearm is going to be in the backyard near the tire, how can you construe that other than an implicit? When you get there, the firearm is going to be in the backyard near the tire.
So, Your Honor, I think that's kind of gets controlled by Commonwealth v. Rogers, where the court held that the person being asked, in that case, actually asked specifically, where is this individual? The individual points to the kitchen. That was not consent to go into the house and search the kitchen. So it has to be unambiguous. It has to say.
But here there was no question to the defendant other than if you want to say anything, you can. I mean, it was just not really much of a question. Which not about like where's the gun or you know what were you doing earlier, anything.
Well, I think that makes it even more ambiguous, Your Honor, because now there's no question posed. He's just being asked about, not being asked about anything, but just saying there's a gun here. That's not saying, here, go search this area.
So what else could he mean? Why would the defendant say the firearm's going to be in the backyard near the tire if he wasn't implying that they could go look there? Is he saying the firearm's going to be in the backyard near the tire, but you can't go look there?
Well, I think that the consent has to be affirmative, not just implied based on the totality of the circumstances to say, well, it could be consent because he has no other reason. There has to be showing, again, the burden's on the Commonwealth to show he actually consented to a search. And just say, well, pointing is enough, this is already like Rogers disclosed. And then, again, talking about Rousseau a little bit here, trying to compare that case, the big difference there is that it's a car versus a home. And here the judge found it was in the curtilage of the home. To just say, here's something in my home, doesn't mean you can search my home just because I'm telling you something's in my home, inherently. You never know why the police might want some of that information, but I don't think it inherently gives the right to consent to search it just by saying there's something in my home, and therefore you have to have the right to search it. Briefly as to the other two issues, the video authentication here, clearly this isn't one of the two preferred methods for authentication where there's an individual who's actually on scene to say that this is a fair and accurate representation of what happened at that time, or somebody with knowledge of how the recording was created. Instead, it's the circumstantial evidence here. I think the key factors for this circumstantial evidence has to do with the fact.
The Commonwealth cites some cases where the Supreme Judicial Court seems to be quite flexible about video coming in. Are those cases wrong, distinguishable?
It's a flexible standard, Your Honor, and it's a totality of the circumstances type standard. It's not something that every case can be judged based, every case has to be based on the circumstance within that case. And here, compared to, I believe it's Davis is the case the Commonwealth cites most heavily, there's differences, and including the daylight versus the nighttime appearance of the situation, the way it appears in the exhibit that was brought in from months later still looked the same, so all you have is the same individual appearing without a timestamp.
If the video were from the day before or the week or month before, would that make a difference?
Well, I think it would make a difference as far as then it should have been, the date of the complaint would have had to be amended and potentially changed. The whole context of the case would have been a different defense. Seeing my time is about to expire, unless Your Honors have any further questions, I'll rest on my brief.
Thank you very much. We'll hear from the Commonwealth.
Good morning. May it please the Court. Jennifer Cohen for the Commonwealth. If it's all right with the Court, I'll start with the Rule 36 argument and address Justice Sachs's question earlier. Does it make sense that reconsideration can occur in this context? And I think when we're on the road to trial, being able to reconsider earlier rulings is very important. It's important to both parties. I can envision a scenario where one judge decides a motion in limine based on a proffer, and at trial, the testimony that comes in is very different than what was represented, and it would be...
Is the Commonwealth willing to both live by the sword and die by the sword? Because you could have a judge turn around. Parties have been, you have one judge who says, no, this is not going in the Rule 36 calculation, and then another one judge says, yeah, that was wrong, and the case is dismissed. You're okay with that?
I mean, I think
it's
that...
both ways.
I'm okay both ways, because I do think that had the outcome been different here, then perhaps the Commonwealth would have chosen to appeal the ruling if the motion, or if there had been a dismissal.
Right, but if the issue is inherent authority, it seems like if they have the authority, then it can cut against the Commonwealth.
I agree, Your Honor. I think that's correct.
Okay.
And I suppose in my other hypothetical, I was imagining that could cut against the Commonwealth just as much as it could affect the defendant.
Do you see any difference between a Rule 36 situation where parties have relied, for example, because, let's say it's an early part of the case, and then the parties rely, so the Commonwealth, for example, is not pushing that hard because you think the period doesn't apply, but motions in limine are a little different from that.
Sure, they are, Your Honor, I agree. But I would say that in the situation where the matter was first discussed, I do understand that Rule 36 controls the calculation of time on 276, Section 58A hold, but I think the calculation was done in relation to releasing the defendant from custody, and I think had the issue been dismissal at that time, perhaps the Commonwealth would have proceeded differently, where the SJC had already ruled that a certain period of time was told.
Do you think the defendant's right that it should have been the Commonwealth making a motion to reconsider and going back to the original judge?
I think in these, no, I disagree. I would say that inherently this was a motion to reconsider. This was a proper application of a rule from the SJC that had no discretion attached to it. So I think in this situation, where the trial judge deciding the Rule 36 motion properly applied that rule, I think there was no need to send this back to the hearing judge.
As a matter of practicality, if you were to file a motion for reconsideration, do you submit it generally to the court and it's the court who decides which judge hears it? Or is it incumbent on the lawyer to indicate which judge should hear it?
I think that, well, I would say typically if that's done, I think the court, in my experience, does, if something is filed, the court does try to locate the judge that made the decision and arrange for a time for that judge to hear it. I think this sits on different footing as well. We're on the day of trial, and where, again, the SJC ruling was involved. This wasn't a discretionary decision that, I think where it was a clear rule, it was unnecessary in this situation to file and have just Judge Nestor hear that motion.
So it's a clear rule, but it still depends on a particular judge's interpretation.
Well, I guess I disagree that it depends on the judge's interpretation because this isn't a discretionary decision. This is a hard and fast rule that was, with all due respect, incorrectly applied by the judge at the earlier hearing. So I think here, where the time shall be told, it was unnecessary to send this back for Judge Nestor to make that decision. I will turn quick.
Is there any scenario here for the defendant where he's saying, I relied on it, and that's unfair?
I think that he did rely on it. I think he did get a benefit from this and that he was released from custody. I think the Commonwealth could have but didn't appeal the order where, I'm sure I'm going to pronounce this wrong, but Luigi was already a decision made by the court. I'll turn quickly to the motion to suppress issue. The Commonwealth does think that this case is most similar to the Rousseau case, and I think even potentially more favorable because in Rousseau, although the defendant had been given Miranda warnings, the police there did ask a question of the defendant, which was, where is this contraband? And I think in this case, the facts are very similar, and the police never
So can you
asked.
just spell out the logic of, why him telling the police where the firearm was meant I give you permission to search there? Because that seems like one could argue it's another thought.
Sure. So I think there is an implication there where, again, police haven't asked a question of him at all. They're not waiting for him to say anything. He might say nothing. I think where you give the exact location of a thing in the way that this defendant did, I just think there was an implication there that there was consent to conduct the search. And I think it's different from the cases cited by my brother. I think Heath and Rogers especially can be differentiated, where it was a knock on a door, no Miranda was given, the person answering the door had no idea why police were there, it was very early in the morning, their weapons were drawn. I think this case is very different.
So if he had just said, I live in the trailer you were searching, would that be an implication that they could search?
No.
What about if he said the firearm is in the backyard near the tire? Would that be consent?
If no questions had been put to him and that was,
Right.
I think that would be consent, yes.
You see a difference between that and the firearm is going to be in the backyard near the tire?
I suppose now that you've said them both, I do think there is a difference in the wording. I think going to be implies that you're going to go there and find it. I think that However, I think if it was said the other way, I think consent can still be implied.
Do you think the issue was, the issue of voluntariness was waived, at least insofar as it involves intoxication, coercive atmosphere, being surrounded by 7 officers?
So I think I agree with my brother that voluntariness was raised, but I think it was raised in the context of coercion and not intoxication. I do think that in the judge's decision, she clearly said that the consent was voluntary, and I think that while I wouldn't dispute that the evidence showed he may have been under the influence at the time he spoke with police, he walked calmly up to them with his hands up. The officer testified to bloodshot eyes, slurred speech, and I think that's not enough to say that this defendant couldn't have voluntarily consented.
So if the defendant had been found with, say, a package of drugs, and he said, yeah, there's more at my house, is that consent to search his house?
Well, I think that there's a lot of factors that would have to go into that. I think
The same factors as here, just not a firearm.
So he'd been taken into custody, he was placed in a cruiser, no questions were put to him, and he offered to police that I have more drugs in my trailer.
Yeah.
I think that could still be consent.
Where's the line then?
I think the line is, was Miranda given? Was there actual coercion? I think the difference is the Heath case, and I think that situation was a woman was placed in handcuffs, repeatedly asked questions about the keys to her trunk. Her companion was told to leave the scene, so she was alone. There was potential that she'd asked for a lawyer and the police had disregarded her requests. I think that situation, it's very clear that consent was not voluntary. Here you have a situation where no one's asking this defendant any questions. He is in custody, but it's really up to him what he wants to say. And
why does it matter that nobody's asking him any questions?
I think because at that point, I'm not even sure he knew what they were looking for.
Did he know they were looking for something?
As far as I know, he wasn't told anything about what was going on. I think he has his hands up, he walks up to the police, they put him into custody. It's unclear if he was told anything at that point. So I think he's assuming that that's what they're looking for. He's offering it up. I think it makes
right, but that is exactly actually my point. If they're already looking and he knows, then why would he even think he needs to give consent? They're already searching, so what does it matter?
But I think he still didn't have to say what he said. He could have sat there silently, especially after being given Miranda warnings.
So it's the volunteered nater of the
I
statement.
think it's the volunteered nature. It's the fact that he offered it up, no questions put to him. He tells them. I think it changes the whole landscape of the situation.
Right, but that's why I'm you're saying volunteered, but multiple armed police come to the area, they immediately place him in custody. He's sitting there while they're searching seemingly for quite a bit of time. So I'm not sure where the voluntariness part of it comes, right? He hasn't been Mirandized, has he, at this point?
I think he's not Mirandized until he says he wants to talk.
Did he say this statement before he was Mirandized?
No. It was after.
It was after, okay.
So my reading of the transcript sort of indicates that they're just ready to take him.
Yes.
They're ready to take him without any questions.
Yes.
And that's where he was given the opportunity, listen, if you want to say something, you can say something.
Right. I think they were taking their action regardless of what he said. He didn't offer any information prior to Miranda that directed the search in any way. Again, he wasn't asked to provide any information. He could have sat there silently. I think it just makes this a very different situation to where a defendant is, repeatedly asked questions, or I think it seems very clear to me that this was offered up by this defendant of his own volition.
Can you distinguish between whether the statement he made was voluntary, as one issue, and whether the statement he made gave consent to search as a separate issue?
So I think, Your Honor, raising the issue of the exact verbiage used kind of goes to, was the consent given? And I think that they are different things, because you can say a thing but not understand the implications of what you're saying, and I think that goes to voluntariness. So if he had been so intoxicated that he was unable to understand the Miranda warning, then this case would be on different footing. But I think where he voluntarily made the statement, where he said, I'm going to tell you where the gun was, tells them where the gun was, I think there was consent that was implied. If there are no further questions, I will rest on my brief.
On the drug use by the police officer, the defendant argues that the disclosure regarding possible drug use of an investigating officer falls squarely within the automatic discovery requirements of Rule 14. Do you agree with that?
I think the Commonwealth is required to provide the information within its care, custody, control. I think the Commonwealth did provide initially the disclosure of, the basic facts that it was aware of. Throughout the progression of the hearing, more information became available to the Commonwealth. When it did get the internal affairs investigation results, it did provide another disclosure. I think at the point where the Commonwealth had the information and the defendant was waiting to get that information, I think it's about 29 days, I would agree that that would be included time. But prior to that, I would say that this wasn't information, it's unclear if the internal investigation was ongoing. And I think at the July 2021 hearing, the defense raised that it was aware it should be filing a Rule 17 motion and should file that in advance of the next hearing so that a representative of the Lynn Police Department could be present. So I think where it was acknowledged by defense that that was the course of action that could and should be taken, and then that wasn't done until months later, the defendant shouldn't get the benefit of claiming that that time is included, where he didn't press the issue.
Just briefly on the sufficiency issue, can the Commonwealth do better with a witness from the DCGIS than, is there a record?
I mean, I think as time goes on, it will be perfected, but I think that that was definitely enough information to satisfy Lattimore.
Even without a statement as to how long the history went back?
I think that it would have been helpful perhaps to have that, but I think where it was clear the testimony was there was no record, and I think I acknowledged that it was the way that the information came in. The witness testified to the application process and not necessarily whether or not the approval would be in CGIS, but I think the testimony that she gave was enough to show that there had not been even any application for a license, let alone one granted.
Would the better practice be to just ask the witness, did the defendant have a license on XYZ date?
Oh, of course. I mean, I think that I'm sure as we go along, we'll have a better roadmap for exactly what needs to be asked or the best way to ask things of a witness. But I think in the early days, I think this satisfies the standard nonetheless.
Okay. Okay, thank you very much.
Thank
Case
you.
is submitted. Our next case today is 2023 P 1425 Commonwealth versus Charles Crump. Sure. Are they coming in now? Just hang on a second. Are they coming in now? We're just going to pause. I think some students are coming in to observe, and that door makes, it's like hermetically sealed. It makes so much noise. I can't hear a thing you're saying when people are opening and closing it.
Sure.
And it seems like it's quite a number of students. All right, why don't we start, and then when they come in, we'll just stop.
Great.
A pause. Okay, thank you.
Good morning, Your Honors. May it please the Court, Elizabeth Simonian for the Commonwealth. Today, the Commonwealth respectfully requests that this Court reverse the motion judge's order allowing the defendant's motion to withdraw his guilty plea. This case is simply about a Hallinan claim that spiraled out of control. What was properly before the motion judge was a second-pronged Scott-Ferrara claim where all the motion judge needed to do was consider where the defendant proved a reasonable probability that had he known of the inadmissibility of the breath test, he wouldn't have gone to trial. Instead, the motion judge considered the defendant's supplemental claims that he filed on the day of the motion hearing and apparently allowed the defendant's motion based solely on those claims that were waived and where the defendant failed to attach affidavits.
Why aren't those proper considerations on a Hallinan motion? Just as in the drug lab cases, we look at whether there was a substantial ground of defense that could have been pursued. Why isn't it relevant? Why wouldn't it be relevant that the defendant might have pled based on the seemingly irrefutable evidence of the breathalyzer, even though there was a good motion to suppress and even though there was a good possibility of impeaching a witness? But once the breathalyzer fell out of the equation after Hallinan, the defendant has these other grounds to pursue. And so why is it improper to consider those not as separate claims, but as part of the whole, we're supposed to look at this with a wide-angled lens. Is there a reasonable probability that the defendant would not have pled?
Sure. So that starts us with our waiver issue. These claims were known or knowable to the defendant at the time that he filed his motion in October of 2022. So here, this 30C2 has two built-in exceptions to it.
Okay, so if we don't agree with your waiver claim,
Sure.
then these were proper ingredients for the judge to consider. And if the defendant hadn't raised them here, could the defendant then go back and file another motion to withdraw a guilty plea that did raise these issues?
Well, I would argue that that takes us into the failure to attach affidavits here. If the court disregards the waiver argument, the major issue here is that the defendant did not aver a there's no substantial issue before the court here. There was no substantial evidentiary showing. We don't have affidavits. Well, let me put it this way. The original affidavit that was filed with the original motion is silent on both of those supplemental claims. The only issue that is properly before the court is based on the breath test evidence, and then the defendant raised a medical defense. However, that
we need the affidavit where we have his original affidavit, and because any sentient being could consider that he had a possibility of a motion to suppress and also the police misconduct.
Yes, but the baseline requirement here is that the defendant aver an affidavit.
Okay, but let's just take the Trooper Church issue, right? Because none of those facts are in the defendant's control. Whether Trooper Church committed overtime fraud or whatever, there's not one thing that the defendant's affidavit can offer on that. He could offer, okay, we're letting the students come in. If you can't hear me, you just let me know, but they're being very quiet. If he just said, you just think he needed to say, I would have considered the trooper had this big fraud history? Because anybody could say that.
You're right, anyone could say that, and at this point, we don't have any information. It's the defendant's burden to come forward with evidence to show that Trooper Church was involved in that fraud
So let's pause on
scheme.
that for a minute, though. So is the Commonwealth's position that it didn't have any burden to disclose that Trooper Church had this overtime fraud situation?
So if we're looking in the Brady context, Brady applies up until the time that the guilty plea is entered. And if we're talking exculpatory evidence, the Commonwealth didn't have any exculpatory evidence in its possession, custody, or control at the time that the defendant pled guilty.
So you're putting a pin there. So if the day after the defendant pleads guilty, the Commonwealth finds out that Trooper has this whole massive background, the Commonwealth has no burden to tell the defendant?
I would say that we don't know exactly what Trooper Church did in this matter. All we have are unsworn news articles that the defendant attached to his supplement stating...
But this is, sometimes the Commonwealth, and it's not just you, talks about possession, custody, or control. And at least in the civil context, if you can ask for it, then it's in your possession, custody, and control. And at least in the argument this week and last week, it seems like maybe the Commonwealth is not agreeing with that position, which is a little concerning.
I'm sorry, can you...
If you could ask for the information, like let's say, for example, the information is at my doctor's office and I have the right to ask for my medical records, in the civil context, those medical records are in my possession, custody, or control, because all I have to do is ask. And here, the Commonwealth could just say to the police department, is there a problem with this police officer? Right? Because there's a lot of newspaper articles that list every one of these troopers that was implicated.
Correct.
And so at that point, the Commonwealth could ask. And I don't know that it's a good policy for us to say, oh, you didn't ask, that's fine. Don't ask, don't tell, that's okay.
I would argue here that the Commonwealth has done some record checking. We have checked our lead portal. There is no evidence there of Trooper Church in any misconduct. We have also checked the Post Commission, which is a public database. There is also no record of Trooper Church in that database as well. We have no records that Trooper Church was actually
Right, but you could ask the police department, right?
We could. You're correct. However, that information, yes, we could have asked, but at the same time, the defendant could have filed a Rule 17 motion for post-conviction discovery. We have a letter here that's saying the Commonwealth didn't turn over exculpatory evidence, but if Brady doesn't extend to the post-conviction posture, then, and we don't have that evidence.
I don't know, I've said this probably too many times, but, a large portion of our country is ready to overthrow the government, and it seems like the government should just always be a good actor, at least.
In retrospect, I do agree with you, Your Honor, that the Commonwealth could have asked. The Commonwealth could have asked, but again,
So you go ahead.
The Ferrara-Scott-Hallinan analysis is supposed to look at the circumstances as they existed at the time of the plea.
Correct.
With the one additional ingredient that we pretend the defendant knew at the time that the breathalyzer test would not have been admissible.
Yes.
So when did anyone learn of this trooper's involvement in the overtime scandal?
As far as I know, the issue was raised in the supplement. The Commonwealth became aware of Trooper Church's credibility when this issue was raised for the first time in that supplement.
Okay, but I'm talking not about months, but years. The time of the plea was 2013.
Correct.
Was there any suggestion that anyone knew of the trooper's alleged overtime fraud?
As far as I know, the Commonwealth was not aware of the Trooper Church credibility issue at that time.
Or was the defendant aware of it?
I don't believe the defendant would have been aware because that the allegations made came out well after the fact, but then again, that goes back to the point that if the defendant wanted to properly raise these issues before the court, they had that information in their possession. Those articles that came out alleging Trooper Church's misconduct, they predated the plea. They came out in 2019 and 2020.
Right, but if you're saying they had it because they'd already searched and found them, because if it's just that they're on the internet, then you both had them.
But again, we don't know what exactly Trooper Church did in this matter. We just have news articles alleging that he was disciplined.
Right, but this is the point, though. The minute the Commonwealth, and I'm referring to all of the assistant district attorneys, sees that there's a trooper scandal, do you think that the Commonwealth, like in an ideal government situation, that the Commonwealth would say, wow, we really better make sure that we don't have credibility problems in any of our cases, and that the Commonwealth should proactively cut off any potential unjust testimony or unjust convictions? Or do you think the Commonwealth can just sit back and let the defense counsel do all that work?
No, I don't agree with you. It's difficult here because again, we don't know exactly what he did. So at most, all of this, had the defendant even known at the time of the Trooper Church credibility issue, at most, and he went to trial, assuming he would have averred that in affidavit form, that had he known of the contents of these unsworn news articles, he would have gone to trial. At most, if we're looking at matter of grand jury and the defendant can prove that there were prior false accusations, if that could actually be proved, at most, all of this evidence would do is be used as impeachment testimony. And then it would be for the judge to determine whether that evidence could come in, and then it would be the jury's function to weigh the credibility issue there. So at most, all it is impeachment evidence. It wouldn't go as far to take Trooper Church from taking the stand. And in any event,
the defendant argues that Trooper Church actually made false representations under oath in this very case, and they give an example where he said something didn't happen in one place and he said it did happen in another place.
So as my sister argued, I believe footnote 2 of her brief, she alleges that the misconduct could have occurred in this case and tied to this case based on the fact that the trooper checked off in the Oates-Batts completion record. I believe that is page 108.
All I want to know is if you agree there was a false, I don't need all the details, it's in footnote 4 of hers, but do you agree he made a false statement in this case?
I do not agree. I don't agree based off
Do you agree that he provided contradictory information in this case?
I would like to argue that the fact that the trooper checked off that he observed the defendant driving in that Oates-Batts completion record, and the fact that the trooper said he didn't observe the defendant driving in his police report, driving and operation are synonymous with each other. If we look to the cases where you're looking specifically to the element of operation, operation can be proved by the fact that the defendant was still sitting behind the wheel, which the defendant in this case was still sitting behind the wheel, the keys were in the ignition, and the car was still on. That is enough to prove operation. And the defendant came forward, he admitted.
But observed, the Oates form or the Batts form says observed driving. Maybe he could infer driving from the fact that from all the circumstances when he came upon the accident, but he didn't observe it, did he?
No, he didn't directly observe.
So would you agree that there's a contradiction between
Yes,
All right.
I do agree with you.
Was the Batts completion record under oath?
As my sister alleges, it is under oath, and based off the rule that she cited, it is under oath. But again, that would go to a credibility issue.
Okay.
So I don't believe that
No, it's not. It's looking at Record Appendix 103. It's not under oath.
Okay. So then here
I can see.
That contradiction, it really wouldn't make a huge difference in this case. Again, the defendant, assuming we went to trial, assuming the defendant had averred an affidavit form that he would have gone to trial had he known of this alleged misconduct, had the defendant found exact prior false accusations, that's stacking inference upon inference here just in order to get to that point.
Changing gears for a minute, you two are just slugging it out over who waived what, right?
Mm-hmm.
But you're all arguing waiver. So the defendant argues that at no point in time did the Commonwealth request to present any witnesses at the hearing or offer any further evidence. Do you agree with that?
I would say here that the waiver issue was raised at the hearing, specifically because the Commonwealth cited 230C2.
No, this is a different.
Are you talking about the affidavit
Did the
argument?
Commonwealth ever say, Judge, we need to present some witnesses or evidence?
No, however, the judge did say he considered all of the pleadings here. So based off of the judge considering the pleadings, he would have known the Commonwealth's position here.
Did the Commonwealth ever object to the defendant's alleged new claims in the supplemental? Did the Commonwealth ever say to the judge below, hey, there was no affidavit from the defendant in this supplemental memorandum?
Not specifically at the hearing, but again, in the record appendage.
I know, but live by the sword, die by the sword. So if you want to claim waiver harshly, then you're going to live with waiver harshly. If you want to be a little lax on waiver, then maybe you get the same, but it's,
I would argue that the
you can't have
Commonwealth
two standards.
didn't get the opportunity to raise that. Looking at the trial transcripts, it's clear that the judge was considering those supplemental claims.
So the defendant argues that even if we were to agree with you that new claims were raised in the supplemental memorandum, they can't have been waived because they were raised within the litigation of the first Rule 30B motion prior to any judicial decision. What's your response to that?
Sure, so we can either look at this supplement in one of two ways. It's either an amended motion. In that case, the affidavit was required to have averred something based on those supplemental claims. So if we look at it there, it fails because the affidavit is silent on those issues. If we look at it as a second motion for a new trial, then it fails because not only were the claims waived, but there is no affidavit attached to that supplement saying anything about these supplemental claims. So I would disagree that it's within the litigation, but it would have to be classified as either an amended motion or it would have to be classified as a second motion for new trial. And in fairness of time, if there are no further questions, I would like to rest on the briefing.
I did want to ask,
Sure.
Once the defendant files his motion to withdraw the guilty plea, does the Commonwealth have any renewed discovery or automatic discovery or Brady disclosure obligation at that point? I'm not talking about in the 8 years between the plea and the motion, but I'm talking about after the motion is filed.
After the motion's filed, no, I do not believe that the Commonwealth has an obligation there to provide that. Again, we don't have specific exculpatory evidence. The defendant can claim that there's exculpatory evidence, but it's their burden to come forward.
Let's say the Commonwealth did have it. Let's say the Commonwealth, that your office knew that Trooper Church's credibility had been seriously called into question because of this overtime scandal. Mm-hmm. Would you have had an obligation to disclose that to the defendant once the defendant woke the case up by filing the motion?
I would argue that Brady doesn't apply post-conviction.
You really want to take that position that the Commonwealth, who has a duty of candor to the court, doesn't have an obligation to provide Brady information in its possession once the defendant calls into question the validity of his conviction?
If we had that specific evidence, then maybe it would be different. So, Your Honor, you are correct. Maybe the Commonwealth doesn't want to take that exact position, but again, we don't have that evidence here. So if we don't have anything to turn over, the defendant needs to come forward. It's their burden to prove this motion for new trial. They did not do that here. They just attached unsworn news articles that claimed there was misconduct, that claimed there was discipline, and we have done our due diligence to check the proper databases to find whether Trooper Church is in there, and he's not. So we just have these news articles that are hearsay, which they don't tell us anything other than that he was involved. We checked. There is nothing that we can find that this trooper was actually involved in this scheme. And I would also say the trooper wasn't involved in that scheme at this time. He was doing his job. He wasn't inflating overtime hours because he was on the road. He pulled up to the defendant who had crashed his car at the scene, so he was doing exactly his job here. So, thank you, and again, I would request that the court reverse the motion judge's order. Thank you.
Good morning, Your Honors, and may it please the court. My name is Erica Bruno. I represent the defendant, Mr. Charles CRUMP. I do just want to start by saying that all the Commonwealth had to do to discover any Brady evidence, if Trooper Church was involved at the time, was have a conversation with their own witness. Trooper Church is their own witness, and there were no conversations, no disclosure of any information. But I'll also reach back.
Assuming they did that, what if he invokes the Fifth Amendment?
then I would say, Your Honor, that that was something that the Commonwealth was obligated to disclose to the defense. In this circumstance, based upon what was raised in regards to Trooper Church's credibility, it was properly considered by Judge Gross. Now, we have the Hallinan standard with, setting forth the Scott-Ferreira analysis. Of course, the Commonwealth has conceded that there's the conclusive presumption afforded to Mr. Crump because of the Office of Alcohol Testing's behavior.
So on the information that's in the supplemental motion or whatever it's called, but the church issue and the other issue, do we go through a full Scott-Ferreira Hallinan analysis, or do you get the first prong on those? Or do we just not do that because the point is it's a consideration in the original basis for the motion?
Exactly, Your Honor. So
it's that one.
yes, Judge. The defense's responsive supplemental memo was completely responsive to all of the arguments put forth by the Commonwealth. So the Commonwealth opened to the door by arguing that there was overwhelming evidence in sole reliance on the report by Trooper Church. The defense, in response, argued that the evidence put forth by Trooper Church was not credible.
Do you agree that the analysis focuses on what the defendant knew at the time of the plea?
I'm sorry, Your Honor, could you repeat that?
Do you agree that the analysis focuses on what the defendant knew at the time of the guilty plea, other than the later acquired information that the breath test was inadmissible?
I would say yes, Your Honor, but in this circumstance, this is pulling forth additional misconduct. I think there's a confluence of issues here.
But the issue on your motion is whether the defendant is there a reasonable probability that he would have pleaded guilty if he had known that the breath test results would be inadmissible? If he didn't know of the trooper's alleged misconduct at the time, then how could that be a consideration to whether he would have pleaded guilty?
Judge, the standard is for whether the...
I'm not saying you might not have some other way to raise the issue of the trooper's misconduct, but I'm asking if the defendant didn't know it at the time, and we have no evidence from plea counsel or the defendant that he did know anything about Trooper Church's credibility at the time, then how can that be part of the Ferrara-Scott-Hallinan analysis?
Yes, Judge. What the standard requires is for the judge to consider the facts that have been presented, whether there's other overwhelming evidence of intoxication. That inherently requires the judge to evaluate the credibility of those facts. And what
the credibility of the facts as they looked to the defendant at the time of the plea.
Even at the time.
What case says that the judge can look at what we know today rather than what the defendant knew and his counsel knew in 2013 when he pleaded guilty?
Judge, I believe that's Commonwealth versus Lavranenko, 473 Mass 42, 2015. But even at the time
what in
of the
Lavranenko says that?
I'm sorry, Your Honor.
What in Lavranenko says that?
So the Lavranenko says for the judge to determine whether, based on credible facts, that there was a reasonable probability that the defendant would have taken the case to trial. And so the judge is inherently considering whether there were credible facts for, whether the judge should be relying on credible facts that were presented by the Commonwealth. And so
we can exercise 20/20 hindsight and say, based on what we know now in 2022 or 2024, it looks like the trooper's credibility was destroyed, and therefore we can pretend that the defendant would have considered that in 2013.
Well, Your Honor, even saying I do agree with you that the standard would require Mr. Crump's, an analysis of Mr. Crump's decision at the time of his plea, I do think that it was reasonable for the judge to consider what had occurred with Trooper Church here. What the defendant has presented is reasonably reliable evidence of a lack of credibility from Trooper Church. And so what I would say to that is essentially that the judge properly considered all of this, even under the Hallinan standard that was presented. Does that answer your question, Your Honor?
No, but I don't know that there's a better answer that I can imagine. I don't see how the judge can... we're trying to reconstruct what the defendant would have done in 2013 if he'd known that the breath test results would be inadmissible. I don't know, we're supposed to take a wide-angled lens, says the SJC, but I don't see how that can encompass what the defendant learned later, whether it was in, 2018, 2022, whenever.
At
Well,
least
I
without
will-
doing a separate analysis under Ferrer Scott Hallinan.
Yeah, and
Yes.
maybe having an affidavit from the defendant and his plea counsel saying, well, we had this knowledge of Trooper Church's credibility or lack of credibility, and we thought about the motion to suppress, but we didn't pursue those because we thought the breath test evidence was fatal to our case. Now that we know it isn't, the credibility and the motion to suppress issues would have been good reasons for us not to plead guilty and to go to trial.
Well, Judge, we did also raise the newly discovered evidence issue in this particular motion. And so even if what the court has the legal authority to do is to consider whether there's another legal basis in the record for the judge's decision. And I would point the court to the Brescia decision, where in that particular instance, there was a question after trial as to the credibility of a key witness. And so in that particular case...
The defendant himself.
Yes, but ultimately, the issue there was an issue of credibility that was learned after the fact, after learning of the key important facts that had been alleged. And so what I would say to that is essentially that the court could consider an extraordinary confluence of factors. And I think that's what was presented here. We have the breath test misconduct. We have the misconduct of Trooper Church, not just in the overtime scheme, but also based upon decisions from other district court judges.
So you say the plural there. I see one decision.
I apologize, Judge. Your Honor, yes, it was one district court decision from an arrest that was made just 3 weeks prior to Mr. Crump's arrest. And so this was...
Is there any reason to believe, I mean, we don't have an affidavit from Mr. Crump saying the Trooper Church bullied me or Trooper Church did anything improper in this case. Why should we assume that whatever happened in that other case happened here as well?
Well, I don't think that it's necessarily requiring an assumption, Your Honor, but I will say is that I think it's a reasonable inference that Trooper Church asserted a type of behavior that was aggressive.
So if he did it once, he did it again?
Well, I think it would be fair for the judge to consider when he's analyzing the facts that have been presented by the Commonwealth. The Commonwealth argued that there's overwhelming evidence of impairment here. And in the lens of the judge...
Relying on Trooper Church's police report, which says that the other officer was with him, the other trooper, I forget his name.
But Judge, there was no evidence presented by the Commonwealth from the other trooper. The Commonwealth did not ask to present oral testimony by that trooper. They did not present an affidavit from that trooper. They did not present an affidavit from Trooper Church. They did not make the record. And so what we have here is nothing disputing Mr. Crump's statement that he would have challenged his case, and there's nothing...
Where did he state that?
I'm sorry, Your Honor. He stated that he would have challenged his case in his affidavit, and that is in the record. I'm sorry.
Right, but he doesn't say anything about, I would have challenged, I would not have pled based on Trooper Church's lack of credibility, or I would not have pled because I thought my lawyer told me we had a good motion to suppress.
Well, I think...
It doesn't say any of those things.
So my position is that the affidavit that Mr. Crump submitted clearly encompasses other potential challenges had the case been permitted to move to trial without the breath test result. What Mr. Crump says is that he would have fought his case. And what was available to Mr. Crump that was completely foregone was this potential motion to suppress on not only the statements at the scene when he was immediately put into cuffs, pat frisked, and then interrogated, but also the statements at the police department, which were cat out of the bag statements. And so what I'm saying, Your Honor, and then on top of that, inherently, what is encompassed in a motion to suppress and what's at trial, the heart of the matter is the credibility of this trooper. And we cannot put our heads in the sand and pretend that there isn't this other evidence in question as to
Can we also consider, as we look at his report, that there was another trooper that was with him the whole time? And shouldn't we, can we at least consider the possibility that if Trooper Church's credibility was destroyed, that the Commonwealth at trial would not have offered Trooper Church's testimony, but the other troopers? Just like the Commonwealth wouldn't offer Annie Ducan's testimony at trial about whether the powder was cocaine.
But that trooper that evidence wasn't presented by the Commonwealth. They had full opportunity to present that in their motion, in their opposition. They had an entire year to prepare an opposition, and they didn't present that.
Because we do have cases that say it was fine not to grant the new trial because another trooper was there. Wood and Elves both say it. So, but you're saying here they didn't take that tact.
Correct, Your Honor. They did not take advantage of any opportunity to present that. They had
Right,
a year.
what I don't see you account for, and what the motion judge definitely should have had before him, was that the defendant received an unbelievably generous offer that took an OUI, potential OUI 4 to an OUI 3 and permitted him to serve fully concurrent sentences with other convictions. What do we do with that?
Judge, Your Honor, the judge did consider the benefit of the plea. That's transcript I-9 through I-10. And what I would say to that, Your Honor, is the breath test was incredibly overwhelming evidence that tainted the entire defense mindset in this case. And as a result of that, instead of fighting his case, this defendant was sentenced to 2 years in jail. That's not anything to sneeze at. He was sentenced to 2 years in jail.
Concurrent with a sentence he was already serving. How much time did he have left on that sentence?
I'm not sure how much time he had left on that sentence, Your Honor. I believe it was a minimum mandatory 150 days. I don't know how much time he had left. But to extend for an additional 2 years, this was not something minimal that he was going to plea to. It's not as if this was probation. And especially had there been these viable motions to suppress, and on top of that, these issues that go to the heart of the credibility of the trooper, I think that's absolutely something that the defendant would have reasonably challenged. He's going to jail. Why wouldn't he try to fight for his freedom? I think that's absolutely reasonable, and that's what Mr. CRUMP attested to in his affidavit. Additionally, Your Honors, what I will say is that the Commonwealth had a full opportunity to prepare here. They did not ask for a single continuance. They had many opportunities to do so if they wanted to seek to put on other evidence. If they wanted to pause the hearing, all they had to do was ask the judge to say, Your Honor, I would like an opportunity to speak with my officer. Your Honor, I'd like to move to continue this hearing so that I can present oral testimony. Your Honor, I'd like to move to continue this hearing so that I can have the trooper sit on the stand.
They did say repeatedly we're not prepared to answer the supplemental motion, and the judge was having none of that.
But, Your Honors, they did not file anything in writing. All they simply said was they weren't prepared to address that.
So you filed your memo on Friday afternoon or whenever it was, and the hearing was Tuesday morning after a long weekend, wasn't it?
The Commonwealth filed their opposition after our motion to vacate had been filed for a year. They filed theirs on the Friday.
But we're talking about whether the Commonwealth had a fair opportunity to respond to the points you made in your supplemental memo, right? And that was filed on a Friday?
No, our supplement was filed on the morning of the hearing. Their opposition was filed the Friday before. So they filed their opposition on a Friday.
Oh, I see.
And we filed our supplemental memo the Tuesday morning of the hearing. And if they had wanted more time to respond, Your Honor, they simply could have asked for it, but they didn't. And
do you agree that the two issues the defendant raised in the supplemental memorandum were known or knowable when the defendant originally filed his motion?
Well, I don't think we can say that it was known or potentially knowable, but it's not the obligation of the defendant to go searching for Brady evidence. Simply because the defendant learned of it at a late hour, that's not the obligation
do you think that the Commonwealth's Brady obligation stops once the defendant is convicted? We can put a pin in whether it restarts, but do you agree with your opponent that it stops when the defendant is convicted?
Absolutely not, Your Honor. I think that would be a very serious miscarriage of justice had that been the standard. And
do you have a case that says that the Brady obligation lasts after the conviction?
Your Honor, I don't have a case that speaks to that, but I'll just speak to the broader history of the Hallinan decision.
Is there a case?
I'm sorry, Your Honor?
Is there a case?
Well, I'll point the court to the Hallinan decision, because in the consolidation of all of those breath testing, which is exactly why we're here, what was uncovered was years after the fact of when all of these defendants pled, and it was discovered that there was the continuing Brady obligation.
Trooper Church didn't get charged with the crime, right? His discipline was internal and maybe paying back some money.
We don't know, and I think that's part of the problem.
According to the newspaper articles you submitted, right?
Yes, but we don't know what the full extent or the history is there. But what I will say, and I do realize, Your Honor, and I did forget to point out that as far as the Office of Alcohol Testing record that was submitted, that is submitted under the pains and penalties of perjury under a statute, Your Honor, and that's General Laws, Chapter 90, Section 24, 1F. To Section 3, where those are that statement of whether he was observed driving was pointed to under the pains and penalties of perjury, Your Honor.
The form itself omits the statutory requirement?
It does. And so there is on the breath test machine itself, there's an option to select signed under the pains and penalties of perjury. And so that's how the officer does that. But the statute mandates that all of those reports that are submitted.
Do you think it matters whether there's a statute? I mean, don't you think that we just generally, that the police have an obligation when they fill out a report to tell the truth?
Yes, Judge, I do.
That's as implied as the permission to consent in the other case.
Yes, Judge. And even with the filing of an application for complaint, those are also submitted under the pains and penalties of perjury. So we could similarly hold a police report submitted for an application as to the same standard. And I do see I'm out of time. I will ask Your Honors to affirm. Thank you.
I had one further question.
Yes, Judge, Your Honor.
On pages 16 and 17 of your brief, you say that according to that the evidence shows that the exclusion of the breath test result would have impacted counsel's recommendation whether to accept a plea. That's the phrase numbered 4 on page 16, and then about a third of the way down the page on page 17.
Yes, Your Honor.
Is that what the record shows?
Yes, Your Honor. So the defendant had submitted an affidavit from prior plea counsel.
Right, page, Record Appendix 58.
And it's Record Appendix.
And what does it say?
Page 58.
Last paragraph.
Yeah, it seemed like you were overselling that because he says it may have changed.
So certainly, he says that it may have changed, but the problem here being is that we can't speculate as to going back in time exactly how any trial counsel would have made their decisions.
Okay, but we rely on what he says in his affidavit, and he says it may have affected my advice. So how can you say in your brief it would have affected his advice?
Well, even if it may have affected his advice, Your Honor, I think that the exclusion of the breath test result in any reasonable trial counsel's view of this record.
I'm not asking you to make an argument on the merits. I'm asking you, please, to accurately characterize the record in the future and not to overstate it.
I apologize, Your Honor.
Thank you.
If Your Honors don't have any further questions, I'll ask that you affirm, and thank you.
Thank you both. We understand your positions and the case is submitted. And since we're cautioning counsel, I'll just say this was directed to the Commonwealth, but in the addendum, you provided an order on appeal that was handwritten, and our rules require that you have that typed up for us. It was fine in this case, but sometimes it is very difficult for us to tell what the order said, particularly when they write sideways. Thank you very much.
Vigorously argued on both sides.
Yes, definitely. Nice job, everybody. We're going to hear our third case of the morning, and then we'll take our mid-morning break. Case is 2023-P-0568, Commonwealth versus COTTO, or COTTO. Let's just give our students a minute to file out.
Good morning, Your Honors. My name is Attorney Carl Suchecki. I represent RICHANETTE COTTO in this matter. RICHANETTE COTTO was involved in a car accident. She was convicted of negligent operation of a motor vehicle. And it's our contention, Your Honors, that the Commonwealth did not prove that. Ms. COTTO that day was driving. She said that it was a clear day. There was no impediments. She was not on her cell phone. She was driving, taking a left-hand turn. She had a green light. And as she entered the crossed over the line, she, unbeknownst to her, a pedestrian, she hit a pedestrian. She didn't see him, and apparently he didn't see her. And as the video will show, the pedestrian walked. He had a red "Do Not Walk" sign. Walked through it.
What was the evidence about why she didn't see him?
Well, there was the defense evidence was that there's an A-pillar on the...
But the A-pillar might have blocked the visibility for maybe a second.
Correct.
One can see from the video that there was a clear line of sight from the driver to the pedestrian for quite a while before...
Well, that's from a view from a camera, Your Honor. But from the view of Ms. COTTO might be different. In fact, Officer Roderick...
We can see the windshield of the car, and we can see what angle it's at, or that not we, but the jury could infer that that A-pillar was not blocking the view of the...
Well, in addition to the A-pillar, there was also the subject of Ms. COTTO's height, which Officer Roderick conceded when he was on cross-examination that they did not consider her height in the factoring of what she could or could not see, and she's short stature.
The jury can't infer that she could have seen anyway, or that if she couldn't see a pedestrian who was in a crosswalk, 30 feet away from her when she made the turn and once the A-pillar was out of the way, that if she was short enough that she couldn't see a pedestrian at that distance, then maybe it's negligent to be driving, or maybe she needs to raise her seat.
So I think sometimes just the fact that a mere accident happened doesn't necessarily mean there's negligence, and in this particular...
Couldn't the jury not infer from the video that the defendant either was not looking and didn't see the pedestrian in plain view, or that the defendant saw the pedestrian and somehow didn't stop, whyever that might be?
I don't think, Your Honor, based on these facts, a rational jury could come to the conclusion that sometimes an accident is just an accident. And the pedestrian, and this is all inference on my part, but she's taking a turn, and there's a red, "Do Not Walk" sign, and there's a pedestrian coming to the sign, and she's got a green light. She's taking the turn.
Pedestrians do that all the time, and you have to take that into account as a driver.
Correct. But also something to consider, but not, is that after this accident, the city of Taunton changed the intersection. Instead of just being one lane, they made 2 lanes. They made arrows in the road to suggest you take a left turn here. And in fact, one of the reasons why the officer gave her a ticket that day was he thought that she should have, or felt that she should have moved over to the left lane to turn, and she didn't.
So
she took the turn wide.
You mentioned in your brief that the investigator had taken some pictures from inside the car of a pedestrian outside the car. Were those photographs entered into evidence?
I can't answer that question. I don't know.
Okay, because I didn't see them in the appendix.
I don't know, honestly.
Okay.
So
but the Commonwealth argues basically that you can see on the video that there's a period where she's heading almost straight at the pedestrian, and nothing in the windshield would obstruct her view. That is one view of that video. And if they're right about that, doesn't that mean that we need to affirm?
I would not say that, Your Honor. I think in this circumstances, Ms. COTTO, by her own testimony, said she was in shock when she saw the pedestrian, the crosswalk. She had the green light. He walked on a red "Do Not Walk" sign. There were no left-hand turn markings. There was 1 lane, not 2. There was no arrow and no street markings. And she wasn't speeding. The officer was very clear.
No, she in fact was only going 13 or 14 miles an hour.
Exactly. She was not speeding.
All right, well, let's assume that it was all on the pedestrian, that she hit the pedestrian, but why can't the jury say, holy smokes, she took 70 feet to stop. If she'd have stopped on a dime in like 25 feet, he might have lived.
At the same time, she was in shock. So what she could or could not do, I don't know, based on her stature, whether she could do things in that way as quickly as possible. But there was no evidence that she was speeding. She wasn't aggressive. She didn't cut anyone off. The citation only came about after the pedestrian died, and they did the reconstruction.
Why does that matter?
Well, just by the sheer fact that they didn't see worthy of giving a citation for her on the scene, they evaluated it, moved on, and then only after he died did they revisit and reconstruct things. So it's just because it's negligence doesn't necessarily mean because there's an occurrence of an accident that it's negligent. And negligence is the failure to exercise a degree of care, vigilance, and forethought that an ordinary person would use with caution and prudence. And it's our contention, Your Honor, that Ms. Cotto used caution and prudence. Unfortunately, there was a tragic accident. Unfortunately, and you could see just by the nature of what the town did after the fact, there was a problem with that intersection. They fixed the problem with the intersection. When you have a contributing factor, but not as contributing negligence, but just a fact of the case, the man, if you actually see the video, kept walking, did not pay attention, did not look either way, and it's just a matter of they both messed up, and unfortunately someone died. So it's our contention, Your Honor, that Ms. Cotto should not have been found guilty of negligent operation of a motor vehicle. If there's no further questions, Your Honor, I'll rest on my brief. Thank you.
We'll hear from the Commonwealth.
Good morning, Your Honors. Henry Souza on behalf of the Commonwealth, Assistant District Attorney for Bristol County. Your Honor, the Commonwealth is asking that you affirm the lower court's denial of the motion for directed finding, applying the standard and looking at the evidence presented by the Commonwealth in a light most favorable to the Commonwealth. I think it's clear that there is sufficient evidence for ordinary negligence. Here, the Commonwealth's position was then, as it remains now, that Ms. Cotto had the ability and opportunity to perceive, identify, and avoid the collision with the pedestrian. The video that was submitted by the Commonwealth is the trial exhibit. And I think in this circumstance, it truly says 1,000 words, and negligence oftentimes can be a circumstance where you know it when you see it.
So you say, or can you, is it fair to say there was a right-hand lane on High Street when there were no lane markings and she was the only car?
If you, in close review of the video, prior to Ms. Cotto's vehicle beginning through that left-hand turn, proceeding through the intersection, traffic is stacked up in 2 lanes.
Right, no, I know, but by the time she comes along, there's not another lane of traffic, and she's just sort of there. I mean, there's a major intersection near my home where, you know, whether it's 1 or 2 lanes kind of just depends on the mood of the first car.
Yep. And certainly there's something to be said about custom versus the plain appearance of the intersection. But I think where the issue lied was the defendant having her vehicle to the right-hand side of the roadway.
But why does that matter? He didn't even look. I mean, he made a poor choice, and he paid a terrible price for that poor choice. But who cares what lane she was in? He wasn't even looking.
Well, Your Honor, it was the opportunity for Ms. Cotto and the duty upon a driver to avoid a collision with a pedestrian in a roadway.
Right, but I don't understand the fixation on whether there were 1 lanes or 2 lanes where she was. That doesn't seem to have anything to do with anything. I see your point that there seems to have been an unobstructed view of the pedestrians. I mean, I get it if someone turns right out of the left lane, but here, you know, she was the only car, so.
And I believe it goes more towards the overall course of conduct, the manner of which the vehicle was being operated, both through the turn, at the point of the collision, as well as immediately after the collision, that when viewed in its totality, assists the Commonwealth in the finding of negligence.
So what was the clear theory of negligence? You talk about throughout, look at what she did throughout. Did you have what was your theory of negligence? In what manner was she negligent, or was it many?
I think the proper answer is many, Your Honor. However, when making the turn, a reasonably prudent driver should be looking to make sure the lane that they are entering into is clear of other vehicles, obstacles, in this case pedestrians. This is a major intersection controlled by a traffic light. There are plainly painted crosswalks. If there's one point on any roadway where a driver should be alerted to the potential presence of a pedestrian, it would be at a painted marked crosswalk. And here, as she's making her left turn, for whatever reason, she failed to identify a person standing in the roadway crossing through the lane of travel. And as the video depicts, as the reconstruction testimony showed, the victim had been in the roadway a substantial amount of time prior to the point of the collision. The driver had the opportunity to see it plainly, even for the sake of argument, including her testimony that the A-pillar may have interfered with it for at least a moment. She did also testify that she saw the victim in front of her vehicle and onto the hood of the vehicle at the time of the collision. She did not...
Not in enough time to react.
But
I mean, that doesn't really add anything,
the
right?
testimony by, I believe, the retired Officer Roderick, who did the reconstruction, was that there was, I believe, about 5 seconds for Ms. Cotto to observe the pedestrian and react, whether it be to swerve, to brake. Again, this is not a circumstance where she was traveling at a high rate of speed. There were no obstructions to her vision on the roadway. It was a clear July day, broad daylight, and the individual was standing in a marked, or walking through a marked crosswalk on a roadway.
So if we broke this into two pieces, the part, before, well, when she hits him and then the part after she hits him, is it enough for negligent operation if we consider just the part up to her hitting him, that she just had a guy directly in her sights in the crosswalk and she hit him? Is that enough right there?
I would argue that that is enough.
Okay.
She failed to use due care that a reasonably prudent driver should have exercised at that point, and she can...
So maybe to put that question a different way, let's assume it was negligent to make a left turn from other than right against the center line marker, whether there was one lane there or two. Does that have a necessary causal relationship to the accident that occurred here, or the impact with a pedestrian?
I wouldn't say that it's necessarily causal to make the turn from a right-hand side of the road.
Negligence would have to cause the death of
Yes,
someone in order to be negligent motor vehicle homicide. So there might have been negligence. The jury could perhaps infer that there was negligence from failure to stop once the pedestrian was in plain view. But does it really matter whether the turn was initiated from the left-hand portion of the travel lane or the right-hand portion?
It certainly wasn't the sole factor as to how the driver of that vehicle found themselves into this position. I think it's a contributory cause that goes to the negligence. It was the manner in which she made the turn, and then the failure to avoid the pedestrian, and the failure to promptly react, or react as a reasonable driver should have. There was testimony provided and evidenced at the trial that the average reaction time was about at 1.5 seconds in daytime based on studies, and at the low speed at which she was traveling, 13 to 14 miles per hour, there was ample time, one, to avoid the crash, and secondly, once becoming aware of the pedestrian strike, to appropriately bring her vehicle to an immediate stop. The testimony was that traveling at that speed, the crash reconstructionist estimated that she'd be able to stop in about 22 feet. Instead, the vehicle continued for 70 and continued to drag the victim that length, as well as evidenced in the video, making lateral motion, pulling the vehicle over to the side of the road while continuing to drive and dragging this person. Excuse me, just one moment, please. To I guess, summarize, the Commonwealth would ask the court to look at those three kind of pieces as part of the overall arching negligence exhibited by the driver, and barring any further questions, I would rest on the Commonwealth's brief.
Thank you very much.
Thank you.
We'll take our mid-morning break. We'll be back in 15 to 20 minutes, and we'll hear the remaining three cases for today. Welcome back to the November 8th, 2024 sitting of the Appeals Court. As I said in the earlier today, for better or for worse in the Appeals Court, we do not have rebuttal. It's 15 minutes per side. And as we are going to do in this case, sometimes we have attorneys splitting. And this, of course, is a reminder that this case is impounded, so please do not use the parties' names, use synonyms. Child, parent, father, mother is fine. This is case 2024 P0561, Department of Children and Families, and another versus father and another.
Good morning, Your Honors. May it please the Court. I'm William Como, and I represent the appellant father. This is a very straightforward appellate issue, whether the juvenile court committed reversible error when it dismissed the father's appeal for failure to prosecute. The answer is yes, and for two reasons. First of all, Rule 10C provides that a motion to dismiss is with notice and a hearing. Because notice and a hearing are required under the rule, the court committed error when it allowed the motion administratively the day it was filed.
Does it say motion and a hearing, or does it say on motion with notice?
It does say.
I recognize the second sentence of 10C refers to a hearing, but
that's right,
is
Judge.
A hearing required?
Yes, Judge. I would think that if you're dismissing an appeal, if you're required to give notice, the notice has to have a purpose, and the purpose would be
couldn't the notice
to be heard.
To give some opportunity for the appellant to file a written opposition?
Well,
is there any case that says that a hearing is required?
No, the rule says a hearing is required, because if it says that if the person corrects the error before the hearing, then it's deemed filed timely. It's deemed corrected. So I would say that the rule requires that there be a hearing. And normally...
Can you help me remember, the motion was filed, and it was dismissed that day?
That's correct. It was dismissed without notice to the appellant. It was dismissed without a hearing. Apparently...
Could it be cured by a later hearing?
Well, a later hearing possibly, but the hearing, the motion that was filed...
Was it cured in this case because...
That's correct.
There was a hearing on a motion to vacate?
That's correct. And it wasn't cured in the sense that he no longer had the opportunity to file the motion for the appointment of appellate counsel or the motion for costs, because he tried to do that the next day. And so had the judge not committed error by dismissing the appeal, this issue wouldn't be before the court today. They would have been allowed to proceed with the appeal and assembly of the record. Had it been done, well, so yes, I suppose a motion bringing up those points to the court may have corrected it, but the motion to vacate the appeal did not address that. Excuse me, vacate the dismissal of the appeal. Excuse me.
The department argues that had the father been permitted to file an opposition or to be heard, that he doesn't ever show that he would have done anything differently or made a different argument. What do you say to that?
I think that's speculation. Father's counsel wasn't the same person who was successful with the single justice and getting this before the court. And I suppose, I don't know the facts outside of this, but I think it's speculation to sort of suggest that he wouldn't have done what he was supposed to do. I think the bigger question...
Did he eventually file the right paperwork just too late?
Yes, the motion to dismiss was allowed on March 7th, 2023. On March 8th, 2023, that attorney filed the motion for costs and the motion for the appointment of appellate counsel. So if the court had complied with Rule 10C, this would not be before the court. But the court did not allow the motions in the sense because the appeal had already been dismissed the day before. So there was nothing that the court could act on because the appeal was already, the case was already closed. And so then they filed the motion to vacate the dismissal, and that was denied, and they appealed it to the single justice, and so that was allowed, and here we are on this very narrow issue.
How do we review the judge's decision regarding I guess the judge denied the motion to vacate the dismissal of the appeal on the basis that there was inexcusable neglect?
Correct. And that's my second argument, is that the court, and I think possibly the clerk's office, have a misunderstanding about the procedural requirements to process an appeal. They seem to have be hanging their hat on this argument that without a motion for costs and without a motion for the appointment of appellate counsel, an appeal can't proceed. Well, Rule 3, 1A or A1, I apologize, says very clearly that once a notice of appeal is filed, that's all you need to process the appeal. And any imperfections or any issues have to be dealt with by an appellate court.
Well, but Rule 9D says that the appellant has to take any actions reasonably necessary to move the appeal along, and then 10C does allow the lower court to dismiss the appeal for noncompliance. So Rule 3 may be a little bit confusing in the sense that it suggests only the appellate court can do something, but Rule 10 is pretty clear that the lower court can.
Well, I think you have two conflicting rules, and I think they have to be read so that the whole is harmonious. And so in this sense, it's very difficult to make that argument that one rule lets you do it and the other rule says you can't do it. The appeal court has to do it. I think the distinction...
Let's look at it this way. Do we have any cases interpreting Rule 3A?
No, not that I'm aware of.
Okay, but we have plenty of cases about 10C, don't we?
Not concerning juvenile court matters, other than a failure to docket an appeal, I believe, may be an issue, certainly an issue that you can argue.
Is there any reason to think that cases involving Rule 10C from other trial courts wouldn't be equally applicable to a juvenile court case?
I think it wouldn't, because the clerk under HC2, the clerk of the juvenile court is required to order the transcript. The appellant is not required to.
Well, okay, that goes to whether the, who had responsibilities here, but that doesn't go to whether the trial court had authority under 10C, assuming there was a proper finding of failure to move the appeal along with, an inexcusable neglect.
Mm-hmm. I don't know. I don't know whether the court has the authority to dismiss an appeal where they are alleging, in this specific circumstance, that the father had failed to file a motion for the appointment of an attorney, for instance. Because under the rules, it doesn't really matter. If you don't file a motion for the appointment of attorney, then trial counsel is your attorney on the appeal.
As to the transcript issue, the department and the Children's Council filed and referred to the Office of Transcription Services policy about how there has to be a motion for costs accompanying the request that the clerk is supposed to make in child welfare cases for the transcript.
With all due respect, Your Honor, they did not cite to the Office of Transcription Services. They cited, I believe, to the Committee for Public Counsel Services.
Well, it says CPCS at the top, but if you go to the OTS website, that's where it is. So whether it's CPCS or OTS, do you agree? I mean, from the face of the policy, I wasn't clear that there did need to be a motion. It seemed to me there needed to be a motion for costs only where the appellant was requesting rush or expedited service, number one, or number two, that it was a non-appeal transcript and the cost was going to exceed $1,000.
That's my understanding as well.
Neither of those seems to apply here. So
that's correct.
So do you think a motion for costs was, while it's required under 3F2,
right,
is it required in order for the clerk to order the transcript?
No. And my argument for that is that, first of all, HC2 doesn't mention anything about a motion for costs, and that's dealing specifically with child welfare cases. And also, the trial court administrative rule 19-1 also mentions nothing about a motion for costs. It basically says the clerk, within 14 days, will fill out an OTS form, send it to OTS. OTS will find a transcriber. The transcriber will contact the appellant to arrange for payment. Well, if that had been done, this is speculation, but if that had been done, it seems likely that the appellate attorney would have said, gosh, I never filed a motion for costs, I'll get that done now. And a year and a half later, we wouldn't be sitting here, and these children would not be waiting to be adopted or to have these cases resolved.
Counsel, you know, in this case, there was sort of a reminder from the clerk's office, you need to do this, and nothing was followed up on. What if, you know, everything happened as you said, that they, you know, they got another reminder, oh, you know, you need to do this, and again, nothing was done. You know, at what point are there no consequences?
Well,
everyone understands the significance of what's on the line for all the parties here, but is there no point at which attorneys are going to be held to their responsibility?
Well, that's the underlying question, Your Honor, and I believe that the rules are set up the way they are because whoever created the rules understood the importance of moving these cases along because children need permanency. And that's why they left the responsibility with the clerk of court to do this. And so to say that, yes, the father had a responsibility to file a motion for costs, or he had the responsibility of filing a motion for appointment of appellate counsel, does not answer the question of who has the responsibility of moving this case along. Those two motions were not necessary to get this transcript ordered. Everything that was necessary was already done, and that was the notice of appeal that the appellant filed. I am not going to cover for what the trial counsel did or didn't do. I don't think I could. But it did not stop the trial court, the clerk's office, from getting done what it needed to be done. They dropped the ball. Father's attorney dropped the ball, but that had no consequence. The clerk's office dropped the ball because they should know, as the father's attorney, but they should especially know what the rules are and what the order of the administrative trial court is to order the transcript.
Does the record tell us whether a judge reviewed the motion or whether it was just kind of granted administratively? I guess the docket has the judge's name next to it, but there's no written order in the record, is there?
The initial motion to dismiss?
The allowance of the motion.
As best I know from the record is that the judge received it from counsel, or the court received it from counsel, and within a very short amount of time, the same day, it was basically stamped allowed, or however the judge did it.
We don't have any paper that indicates a ruling on the motion.
No. Her findings concerning the later motion to vacate the dismissal basically indicated that she initially allowed the motion because father wasn't entitled to be heard because his parental rights had already been terminated, which is just not correct. It's not correct. And then she determined that he had inexcusably neglected to do what he was supposed to have done, referring to the motion for costs, the failure to file a motion for costs, which he had actually done the day after the judge had initially dismissed the appeal, and the appointment of appellate counsel. But again, my argument is that the judge is wrong about that those motions were not necessary under the rules for the progress of this appeal.
So this appeal is from the dismissal. Is it also from the denial of the motion to vacate?
I believe it's just from the dismissal.
Okay.
Yeah.
So the denial of the motion to vacate the dismissal would be reviewed for abuse of discretion, but we're not reviewing that?
The way I am reading the appellate record here, and it took me a while to get my head around it, is that this is a motion, this is an appeal of the denial of the motion, of the denial of the motion.
The allowance of the motion to dismiss.
The allowance of the motion to dismiss. That's my understanding. Just a few more points if the court wants me to move on.
So, I'm sorry.
Go ahead.
So if it's strictly an appeal from the allowance of the motion to dismiss, we're not talking about any discretionary authority of the judge. You're talking purely error of law, failure to follow the rules.
That's correct. That's correct. My argument is that the judge did not follow the rules, the clerk didn't follow the rules, and they're placing the onus on the father simply by his failure to do that. On 2 points, the fact that the judge allowed the motion to dismiss without a hearing in violation of 8C2, and on the fact that it wasn't even the father's responsibility to provide, he was responsible to prepare a motion for costs. But the fact that he didn't do that should not impede the progress of the appeal, because the clerk had responsibilities separate from that. And so that was basically it. One last point, if I may, and that would be that in the supplemental record appendix that was submitted to this court, counsel, the appellees filed the court's underlying findings of fact. That wasn't referenced in the motion for the allowance of the supplemental record appendix, and I would argue that it has absolutely no relevance to this appeal. This is simply a question of whether the procedure was correctly followed on this, and I would ask the court not to consider it.
I don't want to have any ambiguity later once we lose you all. So you're talking about the appendix filed by, is this pleading 11 in our appeal, and are there particular pages that you'd think we should not be considering?
I don't have the specific pages, Judge, but it is the findings of fact of the underlying trial by the juvenile court judge. It has no relevance here, and I have received no transcripts, no exhibits, nothing. I did not even receive that until counsel gave it to me. I was strictly informed that this is just a question of the procedure.
Okay.
As far as we know, the transcripts were never ordered.
That's correct. Thank you.
Good morning. May it please the court? Matthew
Just
Price.
before you start, the clock is correctly set. You're splitting your time. You're splitting your time equally.
Yes, correct.
Okay, thank you. Proceed.
Good morning. May it please the court? Matthew Price on behalf of the Department of Children and Families. The department is asking this court to affirm the decision of the lower court that dismissed father's notice of appeal. The trial court's decision was correct. There was no error in the trial court's decision to dismiss, where trial counsel took no action for 6 months, delaying the child welfare proceedings.
So is there a contradiction between Appellate Rule 3A and 10C?
I don't think there is a contradiction. I think that the controlling rule in this matter would be 3F, which is where 3A is the general, 3F is specifically dealing with child welfare cases.
Right, but 3F talks about what appellant's counsel has to do. It doesn't talk about dismissal of the appeal. That's perhaps implicitly addressed in 3A, and it's explicitly addressed in 10C. So how do we reconcile those two, 3A and 10C?
Well, I think the critical thing is where 3F deals with child welfare cases, specifically because its purpose is to move them along, because speed in those type of cases is important.
If the department and child's counsel really wanted to move this case along, then why the day after appellant's counsel filed the notice of appeal without the 3F2 motions, why didn't the department and the child's counsel either file a motion to dismiss or contact appellant's counsel, say, hey, you forgot to do this, and then that way the goals that we all care about, which are fairness to parents and fairness to children, because childhood is fleeting, those can both be pursued. Instead, the department and the child's counsel waited 6 months.
I don't think it's, wouldn't characterize it that way, because I don't think the appellant has the responsibility to prosecute the appeal. It's his
Yes,
responsibility.
yes,
Or her.
but-
No, if he doesn't, that is ultimately falls on him.
But the
blame
appellant does
can't
have an opportunity to cure under 10C. Would you agree with that?
Yes.
Okay. Was the appellant afforded that opportunity here?
I think the appellant had 6 months to cure it.
No, the cure opportunity is after the motion to dismiss the appeal is made, but before the hearing on the motion to dismiss, according to Rule 10C.
Well, that where it was done administratively, there was no hearing filed.
Does there have to be a hearing?
Held. Sorry?
Does there have to be a hearing?
Well, the point that you made earlier about where the hearing is mentioned in the second sentence infers that there can be a hearing. In this case, I don't think there needed to be a hearing where the amount of time was allowed to cure whatever the problem was. Father had...
No, but the cure comes after the motion to dismiss, right?
Well, I understand...
Opportunity to cure is after the motion to dismiss.
Yes.
And there was no opportunity here after the motion to dismiss because it was dismissed same day.
Correct. But prior to...
Isn't that error?
I think it is not error because he had time to cure the error. He had a lot of time prior to the motion, not after.
The rules speak of the opportunity to cure after the motion to dismiss, after being notified. All your appellate rights are going to go away. You better take some action. And that didn't happen for this father, right?
Well, he had notice. He had an opportunity to be heard. He did have a hearing. He presented his reasoning at the hearing for the 6-month delay. The judge found that there was not excusable error and denied it.
So that's reviewed for what? Abuse of discretion?
Correct. That is my understanding.
Rule 10C says if the appellant fails to comply with 9D or 10A1, the lower court may, on motion with notice by any appellee, dismiss the appeal, but only upon a finding of inexcusable neglect. So upon a finding of inexcusable neglect, doesn't that imply that the finding has to precede the dismissal, or at least be made simultaneous with the dismissal? You can't dismiss unless you make a finding of inexcusable neglect.
Yes. The judge in her findings, or in the conclusion, said that this did not reach a level of excusable neglect. That's why
that was in her written decision on the motion to vacate?
Yes.
Okay. But what I'm asking is, before the dismissal can occur in the first place, doesn't the judge have to make a finding of inexcusable neglect?
I think the judge was effectively doing that in her findings.
Well, but those findings came 6 months later or so, didn't they? The findings on the motion to, denying the motion to vacate were November 1st of 2023. The dismissal occurred on March 7th of 2023, so maybe 8 months earlier. How can the finding of inexcusable neglect made in November justify a dismissal that was made 8 months earlier if the rule says the lower court may dismiss the appeal but only upon a finding of inexcusable neglect? Doesn't that imply that the finding of inexcusable neglect has to precede or at least be simultaneous with the dismissal rather than coming back 8 months later?
No, I would have to say no, I don't think it does.
Well, can the finding of inexcusable neglect be made without an opportunity for the father to be heard?
Well,
yeah, it sure looks like there was neglect here. Father's counsel didn't file the 3F2 motions, but can the judge find inexcusable neglect based on the department's and the children's motion without giving the father an opportunity to be heard before the dismissal occurs?
Well, I think if there was error, it was cured because he did have an opportunity to have a hearing and argue his position. And that would cure, if there was error. He did have notice, and he did have a hearing. I know my time is gone. If there's more questions, otherwise I'll rest on my brief.
Actually, I'll ask you one question, and I don't know what we're going to decide to do, so I want to be very clear about that. If we disagree with you, should we issue an order today saying prepare the transcripts? Or maybe we should just, while we're doing our process, proceed in parallel? Is there a reason not to just order the transcripts?
The original trial transcripts?
Right. If we're going to say that what happened here was not procedurally proper, right, it takes us a while to do our thing, and then that would mean there's even more delay,
Yeah.
right?
I think to make that order to try to streamline so that there's as little delay moving forward as possible is the right decision.
Thank you.
And I do want to, I'm not going to keep you up at the podium, but I just want the department to be aware, there's a case Neuwirth versus Neuwirth, 85 Mass Appeals Court 248. And at 257, it says, we said, although an appellee has no affirmative obligation to nudge an appellant along in ordering a transcript, the appellee risks unnecessary delay if she holds off doing so, knowing that an appellant may be able to take advantage of the cure provision before a Rule 10C motion to dismiss is heard. So you're correct. The appellee has no affirmative obligation, but if the appellee wants to keep the case moving, as I would think the department does in every case to give the children permanency, the department can keep on top of whether the appeal is moving along and move to dismiss or contact appellate counsel and get things back on track right away instead of waiting for 6 months. So just something to think about for the department and department trial counsel in all of these cases.
Understood.
Thank you.
Good morning, Your Honor. Good morning, Attorney Kling. I represent the children both on trial level and appeal. I just wanted to touch on that because there was a lot of confusion around who was the assigned counsel on this case regarding trying to push that forward. Because the attorney who was the trial attorney on this case who failed to do those motions, this was his last trial in the CAFL office. So there was a lot of confusion trying to figure out who this case was still assigned to. And in fact, I know for myself as trial counsel, I didn't understand that there had been a notice of appeal filed until November when the judge issued their findings of fact and conclusions of law on the underlying appeal, because that notice of appeal was never served on myself or the department's counsel.
It's reflected in the docket.
I'm sorry?
It's reflected in the docket, right?
Reflected in the docket, but never served by counsel on us. And I didn't become knowledgeable about that until November.
Well, I'll tell you, the record doesn't.
It is.
The record doesn't disclose confusion with counsel. There's one.
I'm sorry?
The record doesn't. I appreciate you telling me that, but because the record doesn't disclose any confusion with who counsel was. There was one counsel that was appointed, continued to be on the case.
I was trying to explain my actions, Your Honor, in the context of my actions and trying to move this forward.
Yes.
And in the sense that that motion was finally filed because, quite frankly, the only thought that I had to move this forward was really by filing the motion along with the department, based on my own experiences. Mm-hmm. So that's how that happened. It wasn't a deliberate waiting waiting 6 months and let's file it now. It was there was a process involved behind this and why it took that long.
I want to make sure I understand that. So the original notice of appeal that the father filed on September 30th of
Correct.
2022?
Correct.
That was not served on you by father's counsel?
No, it was not.
Was it provided by the clerk's office?
No,
which
it was
the rule
not.
also requires?
I did not receive it. I can't speak for the department, Your Honor.
Okay. So then when did you first
When the
learn?
findings went out in November from the clerk's office, they went out as well. That's when it triggered us, there's been an appeal, because there's findings that have been issued, because the practice in our court is the court doesn't really make findings until they know there's an appeal. And that's why the findings on this underlying issue regarding why we're here today came out in November, came out when they did as well, because that's when they write their findings. So that's kind of like the practice of the court.
Sorry, go ahead.
And you all want us to know those findings existed and said, nudged counsel for the father to do something.
That, my filing the motion was certainly my nudge, Your Honor. Because
Well, yeah,
at
but
that
I mean, there
point,
were a lot of other ways to nudge. I mean, if the whole system is to give parents a fair due process, we have the court, the department, and the attorney for the child, all knowing that the father's attorney is screwing up, right? And I don't quite understand why the response to that is to dismiss the father's appeal rather than just get him new counsel and move on with what's supposed to happen.
you mean the court's response to that?
Everyone else's response
Well,
to that.
I can say just in terms of my position in this and what I was operating under, and based on my experiences with working with this counsel, I took that action because that was the way that I thought I might be able to move this case along.
Well, so were you
because
expecting that
my
the court would
experience is that-
respond by dismissing the case that day without giving him an opportunity to cure?
I'm just responding to this part of it. As to the court, and I can only surmise, Your Honor, from the record, from the fact that the clerk's office had, when they sent out those findings, said, you need to file this ASAP. That was sent out when they sent out the findings to all of us. And that was in November as well. So
We don't have that anywhere in the record, do we, what the clerk's office said?
I believe that was in the judge's findings, but I can certainly,
Well, the judge, there's sort of a paraphrase. The clerk sent an email, that's all we know, I think. The clerk sent an email reminding father of these obligations, but...
right.
Yes, the father's...
My point, I'm sorry, Your Honor. My point is that if the clerk can't nudge him, my nudging hasn't responded to the clerk, he's not going to
You do have a way of nudging, which is to file a motion to dismiss, but you could file that as soon as you know the father has appealed but has not filed these 3F2 motions, which seems to me could have been known as soon as you got the findings and conclusions of law on the termination itself.
Well, I didn't quite discover that the motions had to be filed immediately, Your Honor, quite frankly. And in fact, there's a process that we operate under as all private counsel, or, if you work for the capital offices, there's an assignment intake types of process. So I was pursuing that avenue to make sure that I got appointed on the appeal, quite frankly. And it came up in the context of finally getting a response from them that we don't even know anything about this case. So that prompted the investigation to what exactly is going on here, and which led to that motion.
So once the motion was filed,
yes,
do you think it was appropriate for the court to grant it without a hearing and without having first made a finding of inexcusable neglect? Is that consistent with Rule 10C?
What I would say is that the court, my view is that the court cured the opportunity to be heard part by the hearing on the motion to vacate. And that was done in June, and it was pretty clear in June when that was done that she was not, that the arguments that were made about not really understanding my obligations were not being brought at that
Was
point.
the father afforded the opportunity under Rule 10C after the motion to dismiss was filed to cure the noncompliance?
The motion to dismiss was allowed that same day, Your Honor, and then the opportunity that the court gave was the hearing on the motion to vacate.
Okay, but hearing on a motion to vacate is not the same as giving an opportunity to cure the failure to file the 3F2 motions. In fact, those motions were filed the next day after the dismissal occurred, right?
I think it was that day or the next, it might have been later in the day or the next day, correct. I think the clerk's office got the motions the next day.
So according to Rule 10C, if you had that hearing, the motion to dismiss would have been denied, according to the rule, right?
Well, the rule says that the lower can do this with notice, correct? The lower court may, on motion with notice by an appellee, dismiss the appeal upon a finding of excusable neglect. I think the part that you're referring to is prior to the hearing, if they comply with it, that should be an opportunity to be cured. I'm not, and there's a reference to hearing on that. So I would say that the hearing is not necessarily necessary, but I can certainly understand why this court may look at that interpretation.
Well,
And
let
in
me
this
ask
case-
it a different way. Had the dismissal not entered, and he filed what he filed on March
Correct.
8, would that have cured the problem?
Had the dismissal not entered and he had filed his motions before the motion was, before
the
it was allowed,
dismissal, yeah.
that would have cured that.
Thank you.
And just on the point of whether the motion for costs was necessary in order for the clerk to order the transcripts, the way I read whether it's a CPCS or OTS policy that you submitted, the motion for costs needs to accompany the transcript request only if it's a motion for rush or expedited, or a request for expedited transcripts, or a non-appeal request where the cost is going to be greater than $1,000, neither of which seems to be the case here. So do you think that
Well, I'm sorry, what
what
was
in
that?
what in that policy would have required that the clerk have a 3F2 motion from the father before requesting the
Well,
transcript?
I can just tell you this. This is a part of the thing where the rules kind of meet reality of the situation, how things practice, quite frankly. In our courts, with these types of cases, they are overwhelmingly always indigent clients who can't afford transcripts, motions for funds need to be filed. And the whole point of the rules that we have for child welfare cases under the appeals is the whole point is to move these cases along. And that is why they require those motions to be filed when the notice of appeal is filed, because because they want to move those cases along. There used to be, and I remember this because I was doing appeals back in the day when we had to file all those other things. This was streamline the process, and also that the clerk has to do their obligation to do the transcript.
But under either the rule or under the policy, does a allowed motion for costs have to accompany the clerk's request for the transcript? Or instead, can the clerk go ahead and request the transcript and, make sure that the 3F2 motion is filed later? I just don't see what in the policy requires an allowed motion for costs.
And I guess what I'm trying to say, Your Honor, is that all these rules are interconnected and dependent on each other. And if practically speaking, if the clerk's office had ordered a transcript, it would have sat and nothing would have happened or got kicked back because the motion wasn't attached. And that's...
Why would it get kicked? It doesn't seem like a motion is required for OTS to start the transcript preparation process if it's not a request for an expedited or rush transcript and not a non-appealed transcript costing over $1,000. Why would OTS kick it back and say there's no motion?
Well, that's why I say that there's practice and there's a difference between practice and what actually happens.
Okay, so the
And
policy,
so
the policy that you submitted doesn't accurately describe what OTS is actually doing?
Well, no, there is. I would say that the motion, from my understanding, there is a requirement of a motion for funds. But the bottom line is.
Can you point to me something in the I mean, we want to straighten this out, not just in this case, but potentially.
I'd like this straightened out too.
So what in the policy would have required a motion for costs to accompany the transcript request in this case? This is not a rush or expedited, right? This is
saw
not,
in the policy, Your Honor.
just bear with me. This is not a rush or expedited request.
Correct.
And this is not a non-appeal request where the cost is over $1,000, right?
Correct.
Agree with me there. So I'm just turning to the policy, which
A
I think-
non-appeal case no.
So I'm looking at page 33 of the addendum to your brief, and the heading is Motion for Funds. CPCS requires a motion for the following scenarios. 1, expedited rush services. 2, non-appeal costs exceeding $1,000. No other cases in which a motion is required. And this is
CPCS also requires a motion for funds as well. I understand what CPCS also requires a motion for funds as well as a part of their performance guidelines, but that's a separate issue. But the bottom line is that there's no way to compel payment practically speaking, so that these transcripts are actually done. And unfortunately, with these
Other than to move to dismiss the appeal and then have the appellant be given an opportunity to cure by filing that motion, or else the appeal is dismissed and the transcript request is canceled.
I guess what I'm saying is for the clerk's office, they don't have the ability to push, if they don't have that, with that, they don't have no ability to push OTS, because it's my understanding that regarding dealing with our particular group of cases, the child welfare cases, these kind of cases are the last ones to get transcribed, unfortunately, because of the payment issues with those and their lower cost of payment. So the trial court doesn't have an ability in and of himself to get the transcripts absent it. You can request all you want, it's just not going to happen.
Thank you very
And
much.
just as to the three...
Oh, we're so far over time.
Oh, sorry. Thank you.
Thank you very much. The case is submitted. We'll hear case number 5 today, 2023-P-1428, EAC Realty Trust II and others versus Boston Executive Helicopters LLC and others. And counsel, while you're getting settled, I'll just say I have a number of questions. And so we have already told you a couple of times that we're very familiar with your papers. I would encourage you to get, well, I'm going to interrupt you pretty much very quickly, so.
Good morning. Good afternoon. Jack O'Connor for the Boston Executive Helicopter defendants. With me is Kristen St. George. I'd like to address the 93A issue first, if I can.
The which issue?
The 93A issue, Your Honor, first, if I can. The essential question presented by the 93A Section 11 claim here is whether three acts of simple common law, alleged acts of simple common law trespass can constitute a Section 11 violation giving rise to multiple damages.
You say that we need to read the two 477 Harrison Avenue cases together, and I want to understand what it is that you mean when you say that. Is there something that the second case gives or modifies in the first case?
What the second case does is make very clear that the Section 11 issue, the trade and commerce issue that is one of the issues my clients are concerned about, Your Honor, was not briefed, raised, and directly addressed and discussed by the court.
The first 477 case says essentially that as well, doesn't it, in footnote 11, where they say the defendants maintain that certain claims don't support the plaintiff's 93A claim, but a special motion to dismiss doesn't test the sufficiency of the complaint. Thus, the only relevant inquiry is whether the complaint of conduct relevant to the plaintiff's discrete cause of action provides a substantial non-petitioning basis for the plaintiff's claim. So wasn't 477 dealing only with whether the special motion to dismiss should be allowed, not with whether the plaintiffs in 477 stated a 93A claim?
Yes, the answer is yes, Your Honor. It's an anti-SLAPP case. They both are, and they talk about abuse of process too. And they're Rule 12 cases, and we have a full trial record here. So those cases, and the first one that the plaintiffs rely on, I refer to the underlying folks as the plaintiffs, the flight level parties. It's really off point and doesn't aid them here. Let me, if I can, I want to say that I have just framed the issue whether these three alleged acts of common law trespass can constitute a Section 11 violation. And we have two arguments There's a trade and commerce argument, the procedural argument, and then there's a substantive argument that I don't want the court to overlook if it feels that it's necessary to get to that, because we say two things, that there is no trade or commerce, and also, as a matter of law, in any event, the three simple acts of alleged trespass that are alleged here don't rise to the level of a Section 11 violation, a business person's claim. But let me focus first on the trade or commerce issue, if I can. There are sort of three core facts that I would ask the court to bear in mind, that bear on this issue. One, the theory of the Section 11 claim at trial was that my clients engaged in unfair, deceptive acts or practices. As the court is aware, there are two prongs under Section 11. There's the unfair, deceptive prong, there's the unfair competition prong. And it's important to distinguish between them because the cases treat them differently. And we know for a fact, we don't have to debate the point that the theory that the plaintiffs pursued here was only the unfair, deceptive theory, because counsel during trial said, I'm quoting here, Your Honor, we're not making an unfair competition claim on the 93A claim. So there's no doubt about that. And consistent.
So that definitely says that as we're coming into closing, but on the other hand, somewhere else in the transcript, it says this is exactly 477 Harrison.
They made that argument, Your Honor, but that argument was frankly not helpful to them in any event. For the reasons that I've just discussed with Justice Sachs. That case is off point. That is the argument that they made. It's the only case that they could find during the trial, and it's frankly the only case that they cite in this appeal. But my point is that there is no doubt that the theory here was you violated Section 11 and you're liable under Section 11 on an unfair, deceptive acts or practices theory. That's what counsel said. That's what went to the jury in the special verdict form. That's how the closing arguments were slanted. That was the theory, and that's important as we go forward.
The jury charged on both unfair competition and unfair and deceptive acts?
It was charged on the theory that there were unfair and deceptive acts or practices, Your Honor. And that is an undisputed fact for purposes of this appeal. And I would suggest it's a dispositive fact. So that's important fact number one. Important fact number two is that this claim here does not arise from a business transaction between the parties. And we have another acknowledgement.
But let's leave aside their Coke-Pepsi situation, but let's say you have two, health beauty spas next to each other, and one of them cuts off the water for the other one periodically, causing them not to be able to serve their customers. And I know you said they could always fuel vehicles, but would that be a 93A potential violation?
That looks like an example that appears in the plaintiff's brief, Your Honor, and that would be an example, I would suggest, of an unfair competition type of Section 11 claim, which is not the type that was brought here. Okay, this distinction is critically important to this appeal. So anyway, important fact number two, this claim does not arise out of a transaction between the parties. Now, they are going to try to argue that there was a transaction. They're going to try to point to various disparate details and things and throw them into the cauldron and stir them up and say, oh, well, this all amounts to a transaction. There is no transaction here. Counsel admitted this. I'm quoting again. The conduct between the parties may not be a consummated contract. There were proposals. They never came to fruition. And the evidence is consistent with this. There was some historical fuel sales which have nothing to do with the trespass or the events underlying this lawsuit and this 93A claim. That's it. They're both in business, we certainly agree on that, but this suit does not arise out of a transaction. And that on this record is a fact that can't reasonably be disputed, and that's important because the requirement of a transaction is important. And fact three, and I've hinted at this already, this whole suit is about three alleged acts of common law trespass. They say that we plowed some snow in a big pile in an inconvenient location near their fuel farm.
In the epic winter of 2015-16, and it resulted in like a 70-foot long, 6 feet high, 8 feet deep snowbank. This was not like a little tiny pile of snow.
That's the allegation, and there were photos, there was evidence about this, Your Honor, that there was a big snowbank in an inconvenient location. There was also evidence that those fuel tanks were readily reachable from the other direction. There was also evidence that there were no loss of fuel sales. There was no evidence before this jury that they lost money, that there was any interruption in fuel sales. as a result of this, Your Honor. But that is a common law trespass 1, the snow plowing of the pile of snow. Number 2 is that we allegedly repaved a part of a shared taxiway that's adjacent to the two
Well,
hangars.
it's more than that. It's that you repaved it and then you wouldn't say whether it could bear the weight of a certain heaviness so that they ended up not being able to use the property they were leasing.
That was an argument that was advanced, Your Honor. All the evidence at trial contradicted it. That paving is, in fact, still in use today, and every manner of vehicle traverse it every day. Trucks of all sizes, aircraft, it's in regular use. This was the evidence at trial, Your Honor. So this is, again, a no harm, no foul.
Do we look at the evidence at trial in the light most favorable to anybody, or do we just consider whether there was some evidence in the record?
Well, you're applying the J&OV standard, Your Honor. Essentially, whether there's evidence sufficient to support a verdict, and the verdict that we're focused on, the issue that we're focused on, is Section 11 of Chapter 93A, not common law trespass, Your Honor.
I don't want to get you too far. I don't want to get you too far off track of your argument, but I'm wondering if you want to talk about the use agreement, because it seems like that would be more important than the 93A damages, even when you figure in the attorney's fees. It seems like that would be more important.
Well, Your Honor, I'm going to do my best. I'm going to do my best to talk about all of my issues today, but I do want to start with.
Well, time is limited, so.
Yeah, but time
I don't want to take away from what other questions my colleagues may have, but I have questions about the use agreement.
I'm happy to answer any questions, Your Honor, but I do have some points on 93A that I'd love to get through first, if I can.
We're going to run out of time, and I think we all have far too many questions. And one that I want to get, did you ask your question about the use agreement?
I didn't, but why don't you go ahead?
All right, well, on page 51 of your brief, the first full bullet, obviously I understand these are English language words, but whatever you're trying to tell us, I do not understand. In one page, you talk about the agreement, the use agreement, I can't tell, there seems to be a first agreement and a second agreement and an estoppel agreement and yet another agreement. But whatever you're talking about in this bullet, I have no idea what you mean. None.
The top of 51, Your Honor?
Yes, I mean, I've made a chart. I'm fond of saying that it would be super helpful to have charts. I have a 2-page chart of all of the agreements all of you people have. It's very difficult to understand.
Yeah, it is, Your Honor. And
say that this
the
is
reference
not,
there is to the second use agreement.
Yeah, but so you say the agreement, so I don't know what agreement you're talking about. First, second, estoppel. The agreement was effectively assigned in an estoppel, so it seems like it's different from the estoppel agreement. And then there's a separate document that's an assignment of a sublease, and then there seems to be, then you go to a use agreement, which seems to be different from the agreement.
You must be referring to the first use agreement there, in that,
Yes,
because the second one was only signed on January 30th, and you're talking about January 24th.
That's correct, Your Honor. And, Your Honor, I'm not trying to dodge your question, but this is, quite frankly, a quagmire. And I can't do it justice here in the few minutes that I have remaining. What I would commend to the Court's attention is the summary judgment record that is in the appendix, which walks through this stuff, from my perspective, very helpfully. There's no easy way to get through these issues.
But if we focus on the second use agreement, which, if we focus on it, Joint Appendix 4, page 70, page 26, paragraph 4 of it says, EAC may not assign its rights hereunder without the written consent of SWIFT, which consent shall not be unreasonably withheld or delayed. But it doesn't say anything about SWIFT or SWIFT's successors in interest, which you are, if I'm not mistaken.
Right.
It doesn't say anything about SWIFT assigning its rights to use the westerly part of Lot G. So why do we think SWIFT would have those rights under this agreement where EAC's assignment rights are specifically mentioned and SWIFT's aren't?
One of the points is that all the parties understood, and the practice and the recognition here was that all of these agreements were freely assignable. I think that's the point that we're trying to make.
Talking about summary judgment, when you say all parties recognized they were freely assignable, we're looking at the text of the agreement. What in there or another document suggests that SWIFT could assign its rights to use Lot G?
Right. Your Honor, the argument is that EAC recognized that SWIFT had these rights and that follows from that, it reasonably follows from that, that SWIFT would have commensurate rights to assign as well.
Is that the way we usually construe contracts?
Your
If
Honor,
it makes a specific provision benefiting one party at the arguable expense of the other, do we then infer that it's reciprocal, even though it wasn't mentioned? I mean, wouldn't it have been more logical to say in there that each party may assign its rights hereunder, but only with the written consent of the other, which shall not be unreasonably withheld?
Your Honor, I think we can all agree that these instruments are not models of clarity. And what we've done in our papers is do the best we can to argue that these rights were assignable to my clients and were properly assigned.
So what else besides this agreement suggests that there was a recognition that each party had assignment rights?
Well, the asset purchase documents assumed that those rights existed, Your Honor, that SWIFT had the right to assign those usage-related rights to my clients.
What specific language in the asset purchase agreement?
Your Honor, I can't quote you language from the asset purchase agreement, but it included assignments by SWIFT to my clients. That was part of the transaction documentation.
Even if SWIFT particularly and specifically assigned a right to use the westerly portion of Lot G to you, if SWIFT didn't have that right, it couldn't assign it. Would you agree with that?
Oh, I certainly agree with that, sure.
Okay.
We say they had the right.
So then what's in that agreement isn't that relevant unless we can show that SWIFT actually had the right.
And we say that they had it, Your Honor, and I commend the argument in my papers to you. And as I said, the summary judgment records and the chronology of the instruments there, I think the court will find helpful, although it will take some time to parse it.
Right. So the plaintiff argues, though, that if Stahl's rights under the first use agreement had been validly assigned to SWIFT, as you contend, there would have been no reason for SWIFT to enter into the second use agreement. What do you say to that?
I say that the second use agreement may have been a belt in addition to suspenders, Your Honor, but it does no harm. And all things considered, it is consistent with our position here that our clients had the rights that SWIFT had. Your Honor, if I could, I'm out of time here. Can I just quickly address myself to 93A for 30 seconds?
30 seconds, yes, but I mean, I have questions that are not answered on other issues. Go ahead.
I just wanted to point out that this case, in its essence, is about 3 simple acts of common law trespass. That's all. This can't state a 93A, a Section 11 93A violation. That can't be the law of Massachusetts. And I commend to the Court's attention the several cases that I've cited in my brief, including the Brenneman case from this Court, decided on very similar facts that say that there's no 93A liability in these circumstances. Thank you very much.
So you write in your brief on page 17 that BEH/MII have never conducted any aircraft fueling on lots G or H or on the FG taxiway. Does that mean that you did conduct it on lot F? Or you just not, we're just going to be in the dark about Lot F?
No, I'm happy to answer that. Lot F is the lot that my client controls, Your Honor, and they have a fuel farm. They have fuel tanks and fueling facilities on their Lot F.
And you want to be able to conduct refueling operations on that part of Lot G.
And
your point is just that you haven't done so to date.
That's correct, Your Honor, yes.
Not that you're saying you don't have a right to, because you're asserting.
Exactly, that's right. We do fueling activities on Lot F, and also on distant parts of the airport, not on Lot G.
Got it.
Are they, basically, the appellees are arguing that the excluded evidence concerned flight level's legally protected petitioning activity regarding your client's efforts to become a FBO at the airport. Are they correct about that?
So that issue, Your Honor, it dovetails a little bit with the 93A issues here because, the plaintiffs in their brief now in response to our 93A arguments are trying to make an anti-competition type of argument that they didn't present below, and they're trying to invite the court to decide the 93A issue on those grounds. And that dovetails with our arguments about the trial judge's evidentiary rulings because we tried to offer some evidence to sort of fill in the cosmos on a lot of these issues and the relationships between the parties and what was happening and why they were happening, and he wouldn't do that. And he said, because we've already decided that the competition-related aspects of this case are out of the case. And I interpret your efforts, Boston executive parties, to talk about the various issues as related to competition. I'm not going to let you do that. You can't go there. And so we were sort of restrained from going there, Your Honor. And we tried the case on the basis that the court, limited the parties to, which is these 3 acts of trespass. And, the court, of course, is aware of the result. So we argue that those acts of trespass, can't support a 93A Section 11 finding. And the response is, oh, well, but you did all these things, and you did it unfairly to compete with us.
So let's
and
assume,
that satisfies Section 11.
Let's assume we agreed with you that this didn't state a 93A claim. So do we still need to resolve your challenge to the motion in limine ruling? Because did the motion in limine exclude evidence that would have been relevant and made a difference on the trespass claims?
So it's a good question, Your Honor. And I would say, yes, you do still need to decide the evidentiary ruling.
How would the evidence that was excluded make a difference on the trespass claim? Aren't the facts of the trespass claims kind of undisputed?
Well, probably not a lot of dispute there, Your Honor.
You could fight about the damages, but whether okay.
I will, Your Honor, your implicit point that the evidentiary ruling issue is more important to the 93A part of the case is something I don't disagree with, all right? But I would ask the court, in any event, to consider it with respect to all of the claims.
The Pelleys argue that it's undisputed that your clients refused to disclose the load-bearing capacity of the new asphalt. I get you say that everybody's using the new asphalt, but did your client, for at least some period of time, refuse to disclose the specifications?
I'm not aware that there was any disclosure in response to what my clients have always seen as a completely make-weight position on that issue, Your Honor. It's important to understand they offered no evidence to the jury of monetary damages related to that claim. There was no monetary aspect
Counsel,
to that.
I just want to know an answer. Were they asked to provide the specifications, and did they refuse?
I believe they were asked, and I am aware of no answer to that question,
Thank you.
Your Honor.
Do you have any other questions? Do you have any other questions? Okay. Thank you very much. We'll hear from the appellees.
Good afternoon. May it please the court. Neil Hartzell on behalf of Flight Level Norwood LLC and the EAC Realty Trust II entities, which I would call Flight Level. We are requesting that this court affirm the trial court's judgment on both the summary judgment and the Chapter 93A claims, and also affirm the denial of the post-trial judgment rulings. I want to spend a couple minutes talking about sort of the factual background, and then then discuss 93A, and then talk a little bit about this.
I think we kind of know the background. Can I ask you, how does 477 Harrison support your position that you stated a 93A claim here? As I read 477 Harrison, it is only about the special motion to dismiss and whether there was a substantial non-petitioning basis for the plaintiff's claim there, not about whether the plaintiff had actually stated a 93A claim.
Actually, Your Honor, in both of the Harrison decisions, the 2017 decision, and I may have the years off, and there's a second decision, both decisions said that the plaintiff had, or whoever the party was, had properly made out a Chapter 93 claim.
Can you point me to the specific language in those cases which says the plaintiff stated a 93A claim?
I can tell you it's in there because I just read it.
I want you to point me to the...
I don't have the case.
Sir, let me just say...
I don't have the case with me, Your Honor.
Okay, well, there are two cases. They've been briefed extensively. If you want us to think that those cases stand for the proposition you say, despite the appellant's challenges, I would just suggest that you have the language ready to quote to us when you come up to the podium. I don't mean to get impatient with you, and I'm sorry if I sound that way.
No, fair enough, Your Honor.
It's not helpful to say it's somewhere in there when I've looked and I can't find it.
It's specifically in both cases, Your Honor. And Just bear with me a second. All right. Your Honor, I'm not sure I can get you the exact page. I know it's there, I just read it.
Well, I'm going to assume that it's not there unless you send a letter in that has an exact quote saying the plaintiffs, we rule that the plaintiffs stated a 93A claim.
I will be happy to send a letter in, Your Honor.
If there is language.
Let's not have argument, though. It should be quotes. So I want to jump to the heart of the 93A, though, because they're pounding this drum over and over again that you gave up a theory of unfair competition on your 93A claim, and they do seem to have a cite to the Joint Appendix 11 at page 34, where counsel for your client says, we're not making an unfair competition claim on the 93A claim. So do you agree that the unfair competition claim is not part of this case?
I believe, Your Honor, I did say that, and I believe because we weren't having competition claims, anti-competition claims as part of the trial, we were just focusing on the unfair acts portion of Chapter 93A.
So could you plainly and simply explain how these, what he's calling 3 minor acts of trespass, but you can call them major acts of trespass, but how does that rise to a Section 11 level of rascality?
Your Honor, Flight Level has operated as a fixed-base operator at Norwood Memorial Airport and its predecessors for over 30 years. It, among other things, provides fueling services for aircraft. Back in 2012, Boston Executive Helicopters purchased Swift Aviation's hangar. It was an old hangar that had collapsed, and then entered into a lease with Boston Municipal Airport.
It sounds like you're going to get into an unfair competition argument here.
No, it's
I'm not sure where you're going, but it's not.
I'm telling you the background because this is very relevant to the unfair acts. After Boston Executive Helicopters decided to build a hangar and replace where Swift was, they were told the plans that you submitted to the Norwood Airport Commission were too big to allow proper setbacks to comply with the federal aviation regulations. Boston Executive Helicopters ignored that, and after it constructed its hangar, then started this campaign to try and use our Lot G for their business. They first wrote a letter or an email to Mr. Eichley, the president of Flight Level, that said, we want to use your Lot G. Flight Level says, no, you can't. Boston Executive Helicopters then had a lawyer send a letter, well, we can do it under the use agreement. Flight Level says, no, you can't. And then they embarked on a series of acts to try and take over Lot G, one of which was tearing up the asphalt on Lot G without telling us.
Okay, so you may very well be entitled to trespass damages for that, as you were awarded.
This is
How does it rise to the level of unfair or deceptive acts and practices?
Because this is a series of acts designed to interfere and sabotage our business. They're unfair acts. The next thing they started to do was when there was snowing going on, they would go on our lot and plow the snow in, which culminated in this massive wall of snow that was placed around our fuel farm, which effectively blocked the fuel trucks from accessing the fuel farm. Cost us
But how is that? That still sounds like an unfair competition claim that, the transcript says Ms. Fuller said you're not making. How is it not that? How is it?
Well, Your Honor, you can argue this both ways. You can argue it's unfair competition because they were in the process of getting their own permit to sell fuel, and they wanted to damage our ability to sell fuel. But it's an unfair act. It doesn't. I don't think they're mutually exclusive. I think you can have an unfair act and also unfair competition, but we focused in this case on the unfair acts.
It's unfair acts in trade.
In trade or commerce. That is correct.
So what is the trade or commerce?
Boston Executive Helicopters, at that point, was in the process of obtaining its permit to sell fuel. They wanted to do everything they can to disrupt our business and to figure out a way so they could use our lot for their business. That is an unfair act.
But is it in trade or commerce with you, I think is the question.
There's a whole series of interactions between Boston Executive Helicopters and Flight Level.
But no consummated transaction.
That is correct.
So that's I think that's the question.
The lots adjoin, They were trying to damage our business. If you look at that facts of the Harrison case, Your Honor, there was a building that shared a wall with the neighbor, and they wanted to enter into some agreement to use it. They couldn't, which started years of litigation. And in that case, when one of the parties decided to file false insurance claims against the other claim, the trial judge said that's sufficient to make a 93A claim. There was no consummated transaction between those parties either. And what's the point of 93A Section 11 is designed to deter bad acts. What consequences are there if someone like Boston Executive Helicopters, who's a competitor of ours, engaged in a series of acts that is deliberately designed to...
Trespass damages, an injunction against further trespassers, contempt if they continue to trespass despite the injunction?
They've been doing it anyway. In fact, we had a contempt hearing on just on this lot.
Did your client suffer any loss of money or property from the repaving of the FG taxiway?
We could not identify any specific loss of property in that, but the point of that is they were using it to try and bully their way onto our lot. We did suffer money of loss of property because we had to spend about, I may be slightly off on the numbers, about $6,000 to remove the wall of snow, and then when we put up barriers...
Into my next question, which is I can't figure out where the jury got the $13,000 from. I got $6,000 for the snow removal, and there was $5,000 and change for cleaning up the water antifreeze mixture, but that only gets me to $11,700. So I don't know what the other $2,000 was.
There were also some additional evidence put in about there was some overtime for the police. There was some evidence about the cost of the barriers that we put up on our property to try and stop Boston Executive Helicopters from coming on it.
Okay. Because of the snow pile, did your client lose any fuel sales?
We were delayed in being able to provision planes, and we had to ration the fuel sales. I don't believe there was any evidence that we actually lost money on that, other than the time and expense that we had to spend removing the wall of snow and rationing the fuel with the planes that we service.
In terms of the overturning and spilling of the barriers with the water antifreeze mix, what is the state of the record as to whether that spilled mix was harmless? I understand that you were told, well, as an abundance of caution because of these wetlands, you should do some cleanup, but is there evidence both ways on that, or what's the situation there?
It was a mixture of glycol and water, which is antifreeze. It was dumped over. The flight levels lot G is adjacent to wetlands. They were told by the airport manager, you got to get it cleaned up. They consulted with an environmental company who came out and did it. Boston Executive Helicopters says, oh, this is trivial. You didn't have to do anything. Well, that's not what we were told, and that's what we did, and that was the evidence at trial.
So he characterizes these three things as minor disturbances, but it was not enough to show interference with your business that rises to the level of Section 11 rascality. Why is this enough?
Mr. Donovan, the president of Boston Executive Helicopters, his employee, Rob Silva, their pass cards showed they were on the airport the night of the barrier dumping. We have film of them.
Assume they did it. Let's assume you're completely right. They did it. They're scoundrels.
The jury found that they did it.
Okay, but why does that hit Section 11 rascality?
Even to those inured, as the case law says, to the rough and tumble Board of Commerce, this is outrageous. They're doing a whole series of acts to interfere with us, tearing up our property. Oh, then they were filming our employees. Then they're dumping over barriers that we're trying to protect our fuel farm from. They're putting a wall of snow around our fuel farm. This is not somebody who's engaged in a fair competition, even though we weren't arguing competition at trial. This is somebody who's committing a whole series of unfair acts to our detriment, where we suffer damage. And
But that's where I'm still back to. I don't understand. I could completely see it if you were making an unfair competition claim, although at that point it seems like they were only competitor wannabes.
Oh, I'm sorry, I didn't hear the last thing.
It seems like they were only competitor wannabes at the time, because they weren't actually selling fuel.
They were not selling fuel at the time.
So what's the advantage they're getting by being jerks here?
Interrupting our business, causing harassment, telling us that they're going to continue to interfere with us no matter what any court says, which is continued to this day. It it might solve that piece, but it doesn't solve the deterrent effect of coming onto our property and causing damage to us. They're unconstrained by what a court rule says or what the rules of law say. They do whatever they can to try and harass us. There's 2 other cases pending. They blocked in our, which isn't
even
before.
Even if that's true, then our ruling in your favor on the 93A claim is not going to deter them either, yet it's going to stretch 93A beyond where it seems to need to go.
I think this is a poster child, if you will, Your Honors, for a 93A claim when an adjoining business that is now in competition.
Yeah, it might be a poster child for an unfair competition claim.
It's an unfair act. How can this not be an unfair act, Your Honor?
Well, because
what is fair about what they've done?
Because
Nothing.
there's no transaction. That's how it could be not trade or commerce.
Your Honor, the relationship and the back and forth business is enough to constitute, quote, a transaction. And the word transaction, by the way, Your Honor, doesn't appear in the statute itself. And what case law has developed over time, it says you can't have a 93A claim if you've just got a minor trivial dispute between neighbors. One of the cases that's cited is one neighbor didn't tell the other that there was contamination flowing on their property. Court said there's no nexus, you aren't engaged in them with anything. That's completely different from here, where we were previously selling fuel to Boston Executive Helicopters. Boston Executive Helicopters wanted to buy fuel from us at a discount. Boston Executive Helicopters wanted to buy Flight Level at one point. And then failing all that, started these acts of harassment to harass our business. It's an unfair act, and I think it falls well within the statute.
So you say SWIFT could sue, could use a portion of Lot G only as a taxiway in connection with its own business. So if SWIFT just sold exactly itself, then would, to BEH, could BEH then, are you saying BEH would get nothing, or are you saying it could use it exactly as SWIFT could use it?
These are licenses, these use agreements. They don't run with the land. They're not recorded. They're not easements.
I understand that argument, but that's not the question I'm asking.
I'm sorry
asking
if I misunderstood.
So SWIFT has a contract, and let's say, just to take the temperature down, company ABC just buys SWIFT's business. Does ABC have the exact same rights as SWIFT, or no?
Not on this, because you need to get permission from the landlord and the assignor.
All right, so then,
which was never granted. There is no agreement between Flight Level and BEH for BEH to use our Lot G. There never was.
if you have your brief in front of you, it might help you to follow along here. At page 11, at the bottom of your brief, in the carryover paragraph, you start talking about Lot G, but then you switch over to F, and you say, SWIFT was prohibited by its sublease from using Lot F for the storage or sale of aviation fuel. Then on the next page, you say SWIFT sold its interest to BEH, and then SWIFT and BEH made certain amendments to the sublease which permitted BEH to store, use, and sell aviation fuel on Lot F. But I'm like, how does SWIFT convey rights it does not have?
I'm sorry, Your Honor, I was looking at the wrong brief.
It's the bottom of 11 and the top of page 12.
You're talking about the letter that Mr. Eichley wrote to the town?
No, I'm not. I'm talking about the bottom of 11, the very last 2 lines. You say SWIFT basically had no right under its sublease of Lot F for the storage or sale of aviation fuel.
Your Honor, forgive me, I brought too many briefs with me.
It's the bottom of 11.
Okay, now I have it.
SWIFT was prohibited by its sublease from using Lot F for the sale or storage of aviation.
That is
On
correct.
the very next page, you say SWIFT and BEH made certain amendments to the sublease for Lot F, which permitted BEH to store, use, and sell aviation fuel on Lot F. I don't even understand. How does SWIFT give BEH rights you say SWIFT doesn't have?
The rest of the sentence, Your Honor, says, provided BEH obtain all required certificates, permits, and approvals from federal, state,
Right,
and
but you're
municipal
saying
authorities.
that no matter what, on the prior page, that SWIFT couldn't ever store aviation fuel on Lot F.
That is correct.
Well, so if it didn't have the right to store it on Lot F, how could it give someone else the right to store it on Lot F, subject to any certain conditions?
if it never had the right to sell it there, it couldn't get that right by selling its business to BEH. BEH, I think, wanted to do that, but the condition was you had to get approval from everybody to do it, which I don't think was ever
Swift
given.
was, you're looking at bottom page 11, Swift was prohibited by its sublease from using Lot F for storage or sale of aviation fuel. That was the sublease with the BMA? So Swift was sublessee, and...
Yes.
Okay, so
BMA
BMA...
is the landlord, but go ahead.
So to allow the sale of, storage or sale of aviation fuel, BMA would have had to agree to an amendment to the sublease to Swift or its successor.
I believe that is correct, Your
Okay,
Honor.
so where is that accounted for? How could Swift and BEH amend the sublease without including BMA?
Well, they can't. And we're not saying that they could. We're just saying they entered into this agreement, but any amendments had to get all certificates, permits, and approvals from the appropriate entities. It didn't happen. They never got the approvals. Your Honor, I think that I'm out of time here.
You are, I'm looking to see if there's some essential that you feel like you didn't get to make. You've got 30 seconds, but otherwise I think I'm not going to say we understand actually, but you've argued your case.
The second use agreement, according to BEH, somehow Swift Aviation could assign the rights that it had under the second use agreement to BEH to allow BEH to use our lot for their business. But the second use agreement doesn't do that, and Flight Level and BEH never entered an agreement that would allow BEH to use our lot for their business. That's what this whole case is
We'll look
about.
very carefully at all of these agreements.
Thank you.
Thank you. That brings us to the last case of today, 2023 P1434 SORB number 8703 versus Sex Offender Registry Board. This case does include impounded materials, so we'll be referring to Doe, please.
Good afternoon, Your Honors. May it please the Court. My name is Edward Gauthier, and I'm appearing on behalf of John Doe. I'd like to jump into Issue 2. We're arguing that the hearing examiner wrongly found that Doe suffers from a deviant sexual interest in children associated with a increased risk of reoffense without the benefit of expert testimony. I'd like to go right to the Board's regulation. As the panel knows, there are 6 statutory high-risk factors, and there are many risk-elevating and risk-mitigating factors. One of the statutory high-risk factors is a mental deviance that compels sexual misconduct, and it says...
And the hearing examiner didn't apply Factor 1.
Do we know that? The hearing examiner did not explicitly apply Factor 1, but the hearing examiner did so without mentioning Factor 1.
Well, how do we know that?
Because it's...
Deviant sexual interest is language that appears in a number of other factors as well.
The Board regulation says the presence of a statutorily defined mental abnormality specifically related to sexual deviance is significantly associated with an increased risk of reoffense. In the decision, the hearing examiner states these facts and factors show a persistent deviant sexual interest in children associated with increased risk for reoffense. A board hearing examiner is imbued with technical expertise, but they are not psychologists and they're not psychiatrists.
Right, so to apply Factor 1, I think we'd all agree you need expert evidence of some, what doesn't maybe have to be live evidence, it has to be a diagnosis, written diagnosis, et cetera. There wasn't such evidence here, and the hearing examiner didn't apply Factor 1. So how can we as a reviewing court say, aha, you must have been thinking about Factor 1, and you must have applied it but not said so?
Well, because, number one, the language from the board regulation very parallel way tracks the language.
Right, but you agree that the phrase deviant sexual interest appears in other factors as well?
It does appear in various factors, but this is the factor where the board hearing examiner uses this language for a reason in the decision-making
Do you think
process.
that a board, with your experience before the board, do you think that a hearing examiner would find that that factor 1 applies and still classify someone as level 1?
Absolutely not. I want to stress the importance of this.
Wait.
Oh,
Right.
not,
So-
level 1, yes. Yes.
Yes, so someone with a mental abnormality and a deviant sexual interest in children, paraphilia, pedophilia, whatever it might be, could still be classified as a level 1? You think that's what the hearing examiner did here?
The last time my client sexually offended against a child was in 1979.
Well, there are a lot of incidents
not.
that aren't convictions, but that the examiner is allowed to consider.
Well,
Or at least that you haven't challenged the examiner's considering.
So the hearing examiner had before him the allegations from 1985, but was not considered because there were no records. This is the only allegation involving a child in my client's record.
The daughter was 13 at the time of the alleged sexual misconduct, right?
13 to 21, yes.
Right. So the SORB seems to concede that was pubescent, not prepubescent, but although how we would know based on lack of information about her development, I don't know, but.
We don't know anything about that victim's development. But if the importance of this factual finding, if we look at the high risk and risk elevating factors the hearing examiner found, they're all at least 20 years old. The repetitive and compulsive behavior ended in 2004. The adult offender with a child victim was from 1979. All of the risk elevating factors regarding the actual conduct are over 20 years old. It was this statement that my client has a deviant sexual interest in children, which is not supported by expert testimony. This is the one current risk elevating factor. All of the risk mitigating factors in this case, from age to offense-free time in the community to my client's physical condition to the supports he has, are all present. All of my client's sexual offending is over 20 years old, except the one statement by the hearing examiner, a finding that is not supported by the record or expert testimony, that my client currently suffers from a deviant sexual interest in children. That is, in my mind, in my experience, the most important statement by the hearing examiner because of
If the hearing examiner had not used the word deviant, would you be able to make the same argument you're making?
I would make the same argument. It wouldn't be as strong because deviant sexual, the statutory language says that pedophilia is a paraphilia. It is a statutorily defined paraphilia. It is found within the regulation. So an individual who is found by a hearing examiner to have the diagnosis of pedophilia, that is a high risk factor. That is a deviant sexual interest in children.
Right, but if the label deviant were not applied, would you have the argument that nevertheless the hearing examiner must have been applying factor 1, which she couldn't do without the expert evidence?
Is any adult who has a sexual interest in children not deviant? I think that's kind of a superfluous word. An adult who has a sexual interest in prepubescent children is, by his nature, deviant.
So then an adult who has sexual interest in children can't be classified unless there's expert evidence of mental abnormality?
No, what I'm saying is a hearing examiner does not have the medical, psychiatric, or psychological training and experience necessary to diagnose someone with a sexual interest in
And
children.
the hearing examiner would probably agree with you and say, that's why I didn't apply factor 1. If the hearing examiner had said, I'm not applying factor 1 here because there's no expert evidence of a mental abnormality, would you still be making the same argument?
The argument
that the hearing examiner must have nevertheless applied it?
Well, there's actually two parts. The one part is, yes, I agree that there was no explicit mentioning of factor 1. And if the hearing examiner said, I'm not applying factor 1, there's still the problem of making a determination that my client has a deviant sexual interest in children based on his very aged conduct. So it's not just that the hearing examiner found deviant sexual interest without an expert, it's that the hearing examiner found it all based on the record of the case. Issue number 1 deals with the denial of my client's motion for expert funds. And again, we take issue with the hearing examiner essentially, who again is not a doctor, making a determination based on reviewing my client's statement and medical records, exactly what my client's medical conditions at the time of the hearing meant in terms of his risk of reoffense.
Well, so the board says that basically the examiner accepted the medical evidence that Doe presented and accepted Doe's physical conditions and limitations as described. Do you disagree with that?
The hearing examiner gave my client moderate mitigating weight for factor 31, and in her decision, she does reference the medical records and the motion for funds. Our position is she was not entirely capable of weighing that evidence without the benefit of a physician. These are just medical records that were submitted. They're very clear that my client has cervical disc disease, myelopathy, a whole host of problems confined to his home. The MetLife document says my client cannot walk. He can only walk.
Well, except it also says he's relying on a wheelchair part-time. He's rehabbing a tractor. And he doesn't even seem to contend that he was entirely incapable of future offending. Does he?
My client?
Yeah.
Is incapable of future offending?
He's not arguing that he said he relies on a wheelchair part-time or most of the time, but that means he doesn't rely on it all of the time, doesn't it?
According to the record, he can stand intermittently to perform household tasks. He's not bed-bound and he's not wheelchair-bound,
Right.
if that's the question. No, he's not paralyzed from the waist down or the neck down. He can intermittently stand and move about and grasp and bend and lift, but not significantly. That's clear from the medical record.
What's the best-case scenario for the weight that could have been given if Dr. Jackson had been added to the record?
I don't think it's necessary. Well, full weight would be more than moderate weight for whatever that means, but I think an expert would more fully detail than notes in a medical record exactly what his limitations are. The hearing examiner, board counsel, we could have asked his treating physician hypothetical scenarios. Given his current physical condition, what exactly within the realm of criminal offending is possible? What are the likely scenarios? All we know is he can't work, he doesn't walk well, he has back pain, neck pain. We don't know how this impacts the likelihood of him reoffending sexually.
So,
and we
but
can't
the board argues that even accepting everything you say, there was no indication that those physical limitations would entirely prevent future offending. What do you say to that?
Our argument is that there's nothing in the board regulation that requires physical, mental health limitations to entirely limit or eliminate. In order to get full advantage of a risk mitigating factor, you don't have to prove that it's dispositive. The board doesn't only give risk mitigating to age if you can prove that a person is so old they literally can't reoffend. You don't get full risk mitigating weight for sex offense free time in the community or stability or any of the risk mitigating factors, only if you can prove that because of this factor, this person is incapable of reoffending. Incapable of reoffending isn't the standard. I know we're getting close to lunch and we've run over. I would gladly rest on my brief if it gives the panel the opportunity not to miss lunch.
Thank you.
Thank you.
Good afternoon. May it please the Court. Christopher Bohr on behalf of the Defendant Appellate Sex Offender Registry Board. Just quickly with respect to the motion for expert funds, I would suggest that the hearing examiner's ruling denying the petitioner's motion for expert funds was in fact reasonable and was not an abuse of discretion. As she outlined in her decision, the hearing examiner specifically stated why she did not feel that an expert would be helpful in making her overall risk determination. And the case law is specifically clear that the reason for expert funds is not necessarily to assist the particular petitioner, it's to in fact assist the hearing examiner in making their risk assessment, overall determination and classification level. In this particular instance, the hearing examiner specifically stated that the expert, which would be a medical doctor, does not have any specific expertise in the area of sexual recidivism. That's the first part. The second part, the hearing examiner indicated that the documentation that was submitted by the expert that they were looking for was self-explanatory, for lack of a better term. They specifically said that the petitioner had areas of movement that they weren't able to do, and that the petitioner himself testified further by submitting documentation as to what those limitations are. So the hearing examiner specifically stated, I know by the documentation as to what these limitations are. I know by the petitioner's submissions what these limitations are. I don't see the added benefit of value of what the hearing examiner herself is going to get out of that testimony when in fact she did in fact credit the petitioner with physical condition under factor 31. Moving along to the
So his argument back is, well, they could have still done a different weight to the factor.
Could have. I'm not the particular hearing examiner, so I can't say for sure. But I think the hearing examiner noted herself in the ruling in the beginning of the decision that she felt it wasn't necessary, and that the particular expert that he was looking for would not have changed her decision-making process under factor 31, which indeed she credited, and in fact mentioned the fact that the physical condition he's now in would prohibit him from engaging in conduct towards the biological daughter, which was more forceful, but did recognize in terms of the manipulation of the hands and fingers, which he could still do under the documentation. Takes us back to the initial sex offense back in the late 70s, where it was a 6-year-old prepubescent child victim who, during a bath, he was able to sexually offend under those circumstances. So given the physical condition he was in, he certainly was able to do something similar if presented with those facts again. The hearing examiner recognized that because of his physical limitations, he probably wouldn't be able to carry out the sexual offending behavior that he did against the daughter between 1996 and 2004. So I think the hearing examiner recognized those differences and incorporated those in her decision-making process and gave specific reasons as to why the expert wasn't needed given that. Respect to the issue of sexual deviance that counsel brought up, I would suggest, as Justice Sachs had mentioned, nowhere in the decision does the hearing examiner specifically mention pedophilia. Nowhere in the decision does the hearing examiner go to a manual such as the DSM-IV, which was one of the reasons that was quoted in the case law regarding experts. And nowhere in the decision does the hearing cite to factor 1. So with respect to sexual deviance, the hearing examiner actually looked to the board's regulatory factors under 803 CMR 1.33 in the introductory paragraph. It specifically states, and I'll quote it, the board recognized that research supports that the strongest predictors of sexual recidivism for all sex offenders are variables related to antisocial orientation and sexual deviance. So the introductory paragraph of those factors state that variables, which are the factors, they're variables, related to antisocial orientation and sexual deviance dictate classification levels. And then the hearing examiner went on and utilized those factors in making her overall classification determination. Of important note, the hearing examiner specifically said, well, I don't really see any antisocial orientation factors, and she didn't cite to any because those factors are relative to factor 8, which is violence during the sex offending behavior, factor 10, criminal history, factor 11, non-sexual violence, probation violations, problems during incarceration, those are all going to go to antisocial orientation, which the hearing examiner did not consider an overall decision-making process. What the hearing examiner did rely on is factor 3, which is a statutory high-risk factor that specifically mentions sexual deviance. The hearing examiner also cited 2 other risk-elevating factors. And of important note, the hearing examiner does mention in her brief, it's a footnote, it's footnote 8, which is on the Record Appendix, Volume 1, page 13. She actually notes it has to do with factor 4, I believe. I'm interpreting that. She doesn't specifically say it, but she says that she's not going to find this particular offender a juvenile when he offended back in the late 70s. And she says that her making this finding that he was not a juvenile, that he was an adult, actually works to this particular offender's benefit. And the reason why I believe that she says that is because that would then implicate statutory high-risk factor, factor 4, which again goes to sexual deviance. The language is right in that factor. So she's recognizing the fact that by not seeing this particular offender as a juvenile, she's eliminating the application of statutory high-risk factor, factor 4, which increases sexual deviance that she used under factor 3. I think she utilized other risk mitigating factors to reduce this offender's overall classification level. He was reduced from a 2 to a 1, and she took into consideration the fact that he was elderly, the fact that he did have over, I believe it was 18 years offense-free time in the community. So when you took into consideration those mitigating factors, I think what the hearing examiner appropriately did was make this reduction from a 2 to a 1, but ultimately because of the fact that he had the sex offenses in the late 70s, had the issues that she found regarding sexual misconduct in the 1990s and in 2000 to 2004, but then she made a finding regarding the incident in 2009, wasn't found to be sexual misconduct, but she did still find it of note that the petitioner was riding his motorcycle opposite a bus stop with a 13-year-old child and was staring at her. So that was considered under factor 37. So you have a period of approximately 30 years where the offender continued to be involved with offending conduct regarding children.
So one of the points he makes is that there's a very great significance to this level 1 finding, because as you're, that he can't get into senior living, he couldn't get into a nursing home. Do you have any response to that? Because, I mean, that's a huge burden on him.
I don't believe that to be the case. As I recollect, there was a part of the statute that, and I didn't foresee this question coming, so I apologize. There was a part of the statute that indicated that, that I believe level 3s were not allowed to be in nursing homes. I forget the specific part of the statute. There was a declaratory judgment where a superior court indicated that that provision was unconstitutional. So I don't believe there's any particular part of the law which prohibits individuals from going into nursing homes. And even if that was the case, that may have been the case under the old law if it was a level 2, but it's certainly not the case with respect to a level 1. So I don't think that particular issue would be applicable given the circumstances that we sit here today. And unless there's any other questions from the panel, I would rest on my brief and let you guys go to lunch as well.
Thank you.
Thank you.
Thank you very much. The case is submitted. That concludes our session for today. I want to thank our staff and our court officers for all their help in getting us through today's sitting.